Good morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan Soul. You'll ride with me for the next 4 hours of court action. We'll start the day, Lenawee County, Judge Anzalone.
494FH. Mr. Jenkins is present in person. We do have his fingerprints done. He is represented by Rhonda Underwood. So, Ms. Underwood, you did advise that you had an opportunity this morning to speak with Mr. Jenkins.
That's correct, Your Honor. First of all, do we need an MDOC person?
They're on Zoom.
Oh, okay.
So, Mr. Jenkins, did you have an opportunity to read and review the pre-sentence report?
Yes.
All right, and have you had an opportunity to speak with Ms. Underwood about that?
Yes.
Are you satisfied with her as your attorney and the advice that she has given you?
Yes.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, I believe there is a reference to some sort of on page 6 or 5, Your Honor. There's a reference to some gang involvement, and Mr. Jenkins does not belong in any gang, Your Honor. This was just like a neighborhood group of kids.
Okay. So, Ms. Spade, it is on, but the screen is black, so let me try it again. So we're gonna pause for a minute. Is that better? Okay. All right. So yes, on page 5, it states, according to his previous pre-sentence investigation report, the defendant denies being involved in any type of gangs. However, the defendant's mother indicated that he was involved in a group called the Cloud Gang and the Cheddar As Boys.
Sure.
Okay, and he went by the name Paid in Full, Paid and Full. And who did this? Ms. Teskey did this pre-sentence report. I don't have her. Mr. Stevenson, are you here today for my court? Are you the only one here for my court?
No, that's Sarah's case. I'm not sure where she's at.
Okay, all right. So I can strike that. Mr. Stevenson, if you could just make a note that I'm going to strike that. All right. Anything else, Ms. Underwood?
No, nothing else, Your Honor.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
All right. The probation department has computed the minimum sentencing guidelines to be 12 to 24 months. Do you agree with that computation of guidelines?
We would agree with that computation, Your Honor.
Okay. Is there anything you'd like to say on behalf of your client before the court passes sentence?
Your Honor, Mr. Jenkins, I think, has realized that the behavior that brought him here is really counterproductive. He is in for a long time, Your Honor. And he understands that the better he can equip himself to be on the outside eventually, the better for everyone. There is a COBS agreement in this case to the low end of the guidelines, Your Honor. So we will be requesting a sentence of 12 to 60 months, Your Honor. And of course, Mr. Jenkins is very aware that runs consecutive to what he's doing now, Your Honor.
Mr. Jenkins, is there anything you want to say on your own behalf? Can you stand a little bit louder for me?
No.
If you can just take maybe a step forward closer to the microphone, you're pretty soft-spoken. Mr. Jenkins, I realize you're serving prison time on first-degree murder.
Second degree.
Is it second degree? Okay, I show final charge. Oh, that was dismissed. And then that file was pled down to second degree. And what was your sentence on that one?
27 years, 40.
Okay, so, you know, at 27 years, you'll be eligible for parole.
Mhm.
But every time you get one of these, it stacks, right? So this one will stack on that one, and if you get in trouble again, it'll stack on that one. So I just hope that you're able to find your way and not end up in front of the court all the time with these. Where are you currently living?
okay.
You're at Max, all right. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's a sentence of the court that you will serve 12 months to 60 months on each count with the Michigan Department of Corrections. You'll pay a crime victim assessment fee in the amount of $130 and $68 in state costs on each count. These run together, but they run consecutive to the current sentence you're serving. Do you understand that?
Yes,
Now, you do have a right to appeal this sentence. My bailiff's going to hand down to you a notice of right to appellate review. In the center of the page on the right, Ms. Underwood will show you, you need to initial and date it. Today is March 20. And then that's just acknowledging you received the paperwork. That copy comes back to me, just so I know that you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Jenkins, I wish you just luck. Thank you. So students, if you want to go sit up there, there's a sign-in sheet over here. And you can hang out up there in the jury box. All right, record should reflect I received back a signed copy of the notice of right to appellate review. We'll get Mr. Pegues for you, Ms. Underwood.
Robert, can we have a quick sidebar on police before you call
Sure.
that, please?
Please. Neves or Pegues?
Peggy,
Okay.
I don't know how to say it. Peggy, the one you just said. Two things. The PSI indicates there's an agreement for low and low guidelines. Okay, I say I don't have a record of that, so I just wanted to check that you did. I didn't think we did on this one. I don't have a record of it, is all I'm saying, and I don't have a record of it. If you have a record of it, I'm comfortable with it. I just wanted to make sure you knew this one caps one of that. Okay. Then there is a guideline though that wasn't scored like it should be scored. Okay,
Do you know which one
yeah, OB7,
should be scored?
correct.
Judge Middleton is coming through where? Can anybody else hear Judge Middleton? Because I don't, and I don't have a Judge Middleton feed pulled up. Is it something on your computer, Ash? Let me know if somebody else has the same issue, because I got nothing.
Miss Holly, could you approach?
walk straight ahead. The podium was your turn.
Ooh, wait.
Well, it could go either way.
Yeah. I actually didn't recently. Not involved so much, so I can, yes, yes.
Can you guys reapproach?
I haven't thought of this, but that last thing, I'm not giving you the code.
But that is.
That one looks like it is.
So I have to answer them.
You just staff.
Yeah,
Okay.
he took the report.
Okay,
Okay,
Hess was.
okay.
okay.
I just wanted to make sure.
Yeah,
Okay,
yeah.
That's kind of where mine went. Okay.
number.
Alright. Alright.
No, he just, he
He
takes
takes
it from the report.
Okay, because I had one. where she-
Yeah, when I'm done looking at it. So, okay, hold on. All right. So this is in the matter of the people of the state of Michigan versus Eugene Pegues, file number 25-22399 FH. Mr. Pegues is present in the courtroom. Step over a little bit closer to the microphone, please. Thank you. He is represented by Ron Underwood, and we also have Phoebe McClure here from the prosecutor's office. So, Mr. Pegues, did you get a chance to speak with Miss Underwood this morning?
Yes,
All right, and did you get to go through the pre-sentence report with her?
yes, ma'am.
And did you get an opportunity to ask her questions?
Yes, ma'am.
Okay, are you satisfied with Miss Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
All right, so I know we're gonna get to the guidelines in a second, but starting out, Ms. McClure, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence?
On the front page that the sentence agreement was a COPS agreement.
Okay. I actually,
Otherwise, no.
all right, do you, Miss Underwood?
On the front page, Your Honor, it says I'm retained.
All right, we'll change that to court-appointed attorney.
That is correct.
Okay,
And I also, well, let's continue.
okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
I
Ms.
don't believe
McClure?
it does.
No, Your Honor.
Miss Underwood?
No,
All right, so at sidebar, Ms. McClure said that she had reviewed the guidelines and she feels which OB7,
Yeah, but I would withdraw that.
because there's no OB7 for this offense.
There's, yeah, it's a crime against public safety, not a person, so I would withdraw that.
Okay, so the people, the guidelines were computed to be 12 to 30 months. You have no objection to those guidelines?
Correct.
All right, and Miss Underwood, do you have any objection?
correct. Correct, I have no
Okay.
objection to this guideline.
Before the court passes sentence, Miss McClure, is there anything you'd like to say on behalf of the people?
Yes, Your Honor, I just want to make sure the court's aware of the nature of this offense. This was an instance at MDOC at Gus Harrison where Mr. Pegues was upset with a couple COs or ACO, and in passing them in a common area, threw them over the railing in the prison. This could have resulted in very serious harm. Luckily, the CO was not. He was treated for some minor injuries, but and then it ended in multiple COs coming on Mr. Pegues and in essence a brawl between the three of them or two or three of them. So it certainly could have escalated even more, but I think the fact of how it escalated was very severe, and his impulsive actions to do that to a CO were very concerning. I do think the court should consider a sentence that was recommended, which was the 24 months. It is mid-range guidelines, not the bottom. The bottom of the guidelines obviously are 12 months. I just think for the deterrent factor, and a nature of a crime of this nature, I think 12 months is a little low. Mr. Pegues has a number of years left to serve in MDOC. And I think 1 year at the tail end isn't enough of a deterrent to keep him from doing this again in his years coming up at MDOC. So I'd ask the court to consider the 24-month sentence. Thank you.
All right, thank you. Miss Underwood, anything you want to say on behalf of Mr. Pegues?
Briefly, Your Honor, Mr. Pegues understands the nature of what he did. He further understands that it was unacceptable. I am a little concerned about the connection between the preparer of this report and the charging officer or charging person at the prison, Your Honor. It's of concern to me.
So, Ms. Underwood, I did address that when we approached. Ms. Teskey, Ryan Teskey is her ex-husband, which could benefit your client. I don't know what their divorce was like, but he was just the investigator. He wasn't the victim of this offense.
And Your Honor, he wasn't even the investigator. There was an MSP independent investigator. Mr. Teskey just took the incident report at the prison. He wasn't even the MSP investigator that submitted it to our office.
So I don't feel at that point there's conflict.
Thank you, Your Honor. I would ask the court to continue with the cops plea in this matter, Your Honor. I think Mr. Pease was under some, I don't want to say changes in his system, Your Honor, that perhaps exacerbated this situation. And I think that has been discontinued, and Mr. Pease, to me, and at every time I've dealt with him, has been calm and respectful and in no way intimidating. I would hope the court would continue with the cops plea in this matter.
Right. So, Mr. Pegues, is there anything you want to say on your own behalf?
Yeah.
So you're 36 now. How old were you when you went to prison? 19, and you were sentenced to 36 years for second-degree murder. Is that correct?
32.
Sir, please speak up or get closer to the mic. Thank you, sir.
33, Your Honor.
Okay. And I'm showing like misconducts. You've had 1, 2, 3, 4, 5, 6, 7, 8, 9, at least 9 assaultive tickets since you've been there. And you understand that these sentences just stack on the current sentence you're serving, right?
Yes.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense. Don't give a tone until we finish. Okay. The seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing, the criteria and reasons for the sentence on the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Sentence of the court that you will serve 12 months to 7.5 years with the Michigan Department of Corrections. This does run consecutive to the current sentence or any other sentence that you have. I don't know that you have a prior one of these. There is a $130 crime victim rights fee and $68 in state costs. And as I said, you get no credit and it does run consecutive. So Mr. Pegues, my bailiff's going to hand down to your notice of right to appellate review. She's going to show you where to initial and date it. That's for my records, just so that I know that you received a copy of it. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address list on the form within 42 days. Thank you, Mr. Pegues. The record should reflect that you see back to sign.
Good morning once again, everybody. TCF Live on a Super Friday. My name is Dan. It is good to have you here with me today. Courts usually start off slow on Fridays, but there's actually a little bit going on today for a change. Let's go down to Lake County, Ohio. Judge F. Word is ready to get his day started.
Sorry.
As I understand it, the defendant was represented by Lauren Sharon, who later filed something with the court indicating she was no longer
With that,
with defendant law firm, and that somebody named Nova Levante would be
from Florida.
attorney for defendant from then on. Ms. Levante then filed a motion to withdraw, which the court denied because she had never filed a notice of appearance.
Right.
Now, I sort of questioned this yesterday. And who am I appearing for? And was told that Ms. Levante was going to file a notice of appearance yesterday. And was still
She's been
attempting to
she's been
withdraw.
going to file a notice of appearance for about 2 weeks now.
Don't know if she did that,
No,
Your Honor. It's not on the docket.
right.
So,
So how did you get here, and where is Mr. Meyer?
I do not know where Mr. Meyer is. I have not seen him. I am here because the defendant's law firm contacted a company called Disappearance, which contacted an attorney in Ohio by the name of Matthew Lombardi, who contacted me and asked me if I would cover the hearing. So that's where we are.
All right. I mean, how can I have you appear for Mr. Meyer if there's no notice of appearance and there's no Mr. Meyer?
I agree, Your Honor.
Okay. Anything you want to say about this?
No, Your Honor. I mean, we're prepared to go forward, I guess.
All right, well, let's go forward, and you can call your first witness.
Okay. I'd like to call Ms. Ingrid Singleton to the stand.
You can stay right there if you want. Would you raise your right hand? You swear the testimony about gives the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, go ahead.
Please state your name for the record,
Ingrid Singleton,
and please spell it for the record, too.
ENGRSINGLETON.
Thank you. And what is your title?
Records custodian for accounts owned by LBNV Funding.
Okay. And what's your job description?
My day-to-day duties include reviewing and verifying the accuracy of the business records and account documents for the accounts owned by LBNV Funding, in preparation to authenticate those same documents, and then anything else the compliance manager tasked me to do.
Okay. And then, so you would say you're the custodian of the business records that LVNV has,
Yes,
especially those that were received upon assignment of the original debt in question?
yes, sir.
Okay. I'm going to hand you what I've marked as Exhibit 1. Your Honor, may I approach?
Yeah. Thank you.
Could you please take a look at Exhibit 1 and tell me in your own words what that is?
This is the charge-off statement, which was the last statement during the life of the loan.
That's that first page we're looking at, right?
That's correct.
Okay. And then what is the charge-off balance?
It is $23,430.86.
Okay. Did Mr. Meyer receive a copy of that?
Yes,
To your
sir.
knowledge? Okay. Let's look at the next page, if you will, which might be blank on yours. I don't know, maybe not. What are we taking a look at here?
This is the payment history.
So this is the entire life of the loan that was opened through the original creditor, is that right?
That's correct.
Okay. Were payments made on this?
Yes, there were.
And what were the amounts of the payments made on it?
$619.19 for the most part. There was one that was $617.98.
Okay. And the very bottom, what was the last payment on this payment history? Do you see where that was?
Yes, sir. It was on June the 9th, 2024.
And what was the amount of that?
$619.19.
So that was the last payment made on this account?
That's correct.
And then again, if we look at the bottom, there's also the final balance there, is that right?
Yes.
What is the balance of that?
$23,430.86.
Okay. Was this document maintained in the ordinary course of business
It was?
through your job as the custodian of record?
Yes, sir.
Moving right along then. I'm going to hand you what I've marked as Exhibit 2. Your Honor, may I approach?
Yep.
Ms. Singleton, please take a look at that document and tell me in your own words what that is.
This is the bill of sale that shows the transfer of ownership from the original creditor through LVNV's purchasing affiliate Resurgent Acquisitions
Okay, so
to
this,
LVNV funding.
this was sold from, or SoFi Lending Corporation, the original creditor.
Correct.
They assigned the debt to your firm, your office. Is that right?
They assigned the debt to Resurgent Acquisitions and then to LVNV funding.
Skip a couple pages there since you've established that it went through Resurgent, then to LVNV. I want you to take a look at that, what's labeled as Exhibit A in that same packet.
Okay.
And then the following documents, can you please tell me what that is?
This is a printable view of a portion of the schedule of accounts that was purchased in this portfolio, with only the defendant's account being unredacted about halfway down, line number 757. All of the redacted information above and below that belongs to other consumer accounts, and so that's redacted for privacy purposes and has no purpose here today.
Thank you. Take a look at the unredacted part of that document. Whose name is on there?
On the second page of it, you can see that it's Stephen Meyer,
And can you tell me the address as well?
106 Rose Court, Painesville, Ohio, 44077.
And then is there an amount on there, if you keep looking through it? Might be a couple pages down, maybe.
Yes, 1, 2, 3. On the third page, we have the principal amount of $21,602.97, and then the pre-charge-off interest was $1,827.89.
Was this document maintained in the ordinary course of business?
Yes, it was.
And as custodian of record, you keep watch over all of these documents, is that right? Make
Yes.
sure that they're accurate?
Yes, I
Best
do.
of your knowledge? Okay. They hand you the final document here. Labeled Exhibit 3. Your Honor, may I approach? Take a look at what I've labeled as Exhibit 3, and please tell me in your own words what that is.
This is the loan agreement and the truth in lending disclosure.
Okay, and this outlines the amount that was financed by the original creditor, is that right?
It does.
And also the payments that were required from the defendant to make, is that right?
Yes.
As we go through this document, we see some terms and conditions. These are pretty standard, is that correct?
They are.
And does it include documentation or language that shows interest rate and late fees that would be applied
Yes.
according to the agreement?
Yes.
Moving through that, bring your attention to like the third to last page.
Page 10. Yeah.
At the bottom of that, what's the name of this page right here that you're looking at?
This is the signature page.
Okay, and at the bottom, does it contain the defendant's signature?
It does.
What's the, just so that we're all on the same page, there's a bunch of numbers below the signature. Can you tell me what that is?
This is a DocuSign signature. So it's like an electronic signature, and that number below identifies the signature as far as the trail goes to know that it was his signature.
Okay, so according to this document, it appears Stephen Meyer did sign this digitally, is that correct?
Yes.
And what day was that signed?
June the 24th, 2023.
And was this document maintained in the ordinary course of business?
Yes, it was.
Your Honor, I'd ask exhibits 1, 2, and 3 be admitted into the record.
All right, they're admitted.
No further questions.
Well, I'm kind of conflicted here, Mr. Robusto, since you're not really here.
Understood,
But you
Your
are
Honor.
here, so if you want to ask any questions of the witness, you can go ahead and do that.
Sure. Ms. Singleton, referring to Exhibit 1 and Exhibit 3, these are documents that were prepared and maintained by SoFi Lending Corporation, is that correct?
That is correct.
Okay. You are an employee of the current holder of the debt, is that correct? Which is LVNV funding, is that also correct?
I'm actually employed by Resurgent Capital Services, who's the master servicing agent for LVNV funding. We're the attorney, in fact, for them.
I see. Okay. Do you have knowledge of how these records were prepared and kept by the original creditor, SoFi Lending Corporation?
Yes, sir. I've had training by SoFi.
You've had
Training?
training?
Yes, sir.
What kind of training?
It was a training with our company and their company, their department heads and different departments, educating us on their procedures and processes.
I see. You know what? I have nothing else, Your Honor.
All right, thank you. Any other witnesses?
No, Your Honor.
All right. How much you asking for?
Yes, the amount we're asking for is $23,430.86, plus court costs and statutory interest.
All right, anything you want to say, Mr. Robusto?
No, Your Honor.
All right, so I will issue an order, judgment for the plaintiff, $23,430.86, plus costs and statutory interest. And I'll put out a written order.
Thank you, Your Honor.
What was the name of the company that contacted you to be here?
The actual human being who contacted me to be here, his name is Matthew Lombardi, Lombardy. But I believe that the company that contracted him was a company called This Appearance, capital H, capital THIS, capital APPEARANCE, one word. And I believe they are a company that assists in getting attorneys to cover hearings.
Okay. I mean, you can do whatever you want. I know you're getting paid to be here, which is good for you, okay? But you could, if you would be so kind as to inform Mr. Lombardi, who can then choose to or not to let this appearance know that I'm not, from this point forward, I'm not going to let anybody participate in any hearings unless they're the attorney of record. Okay.
Your Honor, I yesterday examined the docket and saw that the court had apparently ordered that attorneys of records be present and
Right.
also clients. So I did notice that. I don't know if anybody else did, but I will pass that on.
Okay.
And that's the end of that. All right, let's go Michigan. Judge Elmore.
Good morning. Welcome to the 28th Circuit Court here in Wexford County. We begin today's docket call by taking up the case of People of the State of Michigan versus Henry Collins. This is case number 19-12592 FH. Appearances from counsel, beginning with the AG's office.
Your Honor, good morning. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office of the People.
All right, thank you.
Thank you, Your Honor. Taylor Chen and
Devento, on behalf of the defendant who joins us from the Wexford Jail today. I was just briefly consulting with the probation officer in this case as well, so thank you.
Also here this morning is Mr. Kevin Stapleton. He's the agent from the Michigan Department of Corrections on this case. And joining us via Zoom from the Westford County Jail is the defendant, Mr. Henry Collins. Mr. Collins, are you able to see and hear us this morning?
Yes, Your Honor.
All right, thank you very much. All right, so we were here on the record earlier this week. The court conducted an arraignment on a probation violation request and warrant. There were some amended counts. There's a total of 4 counts. Come on. Looks like the initial request and warrant was issued back on January 13th, 2021. That included a single count for violating Rule 1, alleging that the defendant had committed child neglect in the state of Oklahoma. And then on March 13th, there was an amended or an additional request and warrant that included 3 more counts. One was for allegedly violating condition 3, failing to make a truthful report to the probation officer since January 4th of 2021. A violation of condition 4 for not notifying the probation department of a change of address back on February 2nd of 2021. And then a 4th count for violating again Rule 1 for testing positive, being convicted of possession of methamphetamine on October 21st, 2020. All right, now that I've gone over what the charges were, we conducted that arraignment to be set for an informal hearing. The defendant requested counsel, which is how we got Ms. Fiorabento here. All right, now that I've covered how we got here, why we're here, let's find out what we're doing. Ms. Fiorabento?
Thank you, Your Honor. I did meet with my client yesterday at the Wexford Jail. He indicates that he would like to resolve this matter speedily and he would not ask for a contested hearing.
All right.
I did not have a recommendation from the probation officer at that time, but I have consulted with Mr. Soliday before coming on the record. I do believe we might have an agreement in place and we could go ahead and plead this thing out today and potentially proceed in the sentencing. If the court would be so gracious as to allow me an opportunity to consult with my client in a breakout room briefly.
Sure, but also Mr. Burke, sounds like Mr. Fiorabento has spoken with the Department of Corrections. While they may have a recommendation and agree to handle it one way, do you know what they're talking about?
I don't know what the recommendation is, Your Honor. I'm sorry.
Okay, good enough. Well, let's go ahead and just state it on the record so that way Mr. Burke can hear it. And well, there we go. Just go ahead. Thank you.
Thank you, Your Honor. And Mr. Soliday, I'm sure can correct me if any of this is.
Mr. Soliday or Stapleton?
Stapleton, I'm
That's
sorry.
okay. I just want to
It
make.
is Friday.
I just want to make sure we know who we're talking about. All right.
Thank you, Mr. Stapleton. I do apologize.
Yep.
Can correct me if there is anything incorrect in this.
Got it.
But my client is being offered to plead guilty to technical violation of new criminal conduct in the state of Oklahoma, new criminal conviction there. In exchange, the recommendation would be some sort of jail or prison sentence at the discretion of Your Honor. We already have a PSI from the file previously. It was a delay. And I would like to discuss that with my client and discuss the possible outcomes here with him if he was to proceed forward with this.
So you said clarify a few things and not argue, just to make sure everybody's tracking. Technically, because they're all beyond 60 days, they're all non-technicals. But so I would need to know which one of the non-technicals for new conduct, which would be count 1 and count 4, which one of the two? Would it be count 4, the one for the methamphetamine conviction? I don't know if it matters.
I believe we would talk about count 1. We don't really have a strong preference one way or another. I would want to consult with my client on that, but.
Okay, and then so really it's just a recommendation that, well, actually, after that, there's a recommendation for jail or prison. What were the guidelines before, Mr. Stapleton or Ms. Fiorabento?
0 to 9, Your Honor.
Okay, all right.
A recommendation, not a sentencing agreement. The ultimate sentence up to Your Honor.
Yep. All right, Mr. Burke, do you have any input there?
I just want to make sure I'm clear on this, Your Honor. I apologize. So the defense is going to be pleading guilty to one count of violating criminal law, even though there's 2 counts. Is that right?
That is correct. They would pick one of the 2. I don't know which one that would be. The count 1 is the child neglect. Count 4 is the possession of methamphetamine. I'm
not
not
sure.
gonna say which.
I'm sorry. I was going to say I'm not sure why he's not pleading to both.
But first of all, hold on. First of all, I do not know, but pleads guilty to 1 or 3 or 4, the potential sentencing is still the same.
Okay.
Right, because I don't really care. This is all between you guys. So we're gonna take a recess here. Mr. Burke, we're gonna put you into the matrix, which will be just a plain white room. All right, digitally. I think you're supposed to take the blue pill. I don't know. Yes, ma'am.
If, maybe, I don't know if there's a way for me to go in a breakout room with Mr. Burke, or if the court could send him my cell phone number and him and I could then talk a little more too.
How about this, Mr. Burke? We're gonna put the 3 of you into a breakout room, and then you can leave it when you're ready. Okay?
Okay. That sounds good.
Thank you.
Thank you, Your Honor.
By the way, does anyone know the French philosopher for whom the Matrix is all about? Rene Descartes. I think therefore I am. Disregard. Take that and discuss it in your breakout room. Mr. Collins, stay right where you're at. We'll be back here hopefully in about 10 minutes. Thank you very much. We are in recess.
Thank you, Your Honor.
All right, we'll circle back to Judge Elmore at some point. In the meantime, we'll head down to Florida for our pretty much daily visit with Wade Mercer.
To 1 count of dealing in stolen property, Mr. Lee, there is probable cause for the charge. Mr. Lee, I've also looked at your criminal history, several prior charges you have. Some of them are juvenile offenses. I'm aware of that. So, Mr. Lee, I think you're entitled to a bond as far as I can tell. I'm going to ask the attorneys if they have any additional information before I set that bond. Mr. McDaniel, anything on behalf of Mr. Lee?
Yeah, just, that he's 19 years old and, I think all his stuff may have been, I don't know how long ago they were. I know he said it was a juvenile, but, I don't know how long ago they were. We just asked for some kind of reasonable bond or reasonable lease option.
Okay, thank you, Mr. Mitchell.
Nothing from the state, Your Honor.
I think the most recent thing I had before this was 2021. That may have been dismissed. It was. Battery on a health services personnel, that was dismissed. And then there was a couple of charges before that. Trespassing, that was dismissed. Lake City. Burglary of an occupied dwelling, unarmed, adjudicated delinquent, April 21. So, Mr. Lee, this is a second-degree felony you're accused of. There appears to be substantial evidence in this case. I'm going to set your bond at $10,000 cash or surety unless you request a cash bond. Mr. McDaniel, would you prefer a surety bond or cash?
Yes, sir. Cash bond.
Surety. Cash bond, Mr. Mitchell, any objection?
No objection.
Your bond then will be $1,000 cash because it appears there may be restitution owed. So it's $1,000 cash. Mr. Lee, if you post the bond, you'll be released. You do have a condition of no contact with alleged victim, Mr. Lee. And Mr. Lee, you will get to use a phone in just a few minutes to try to post that bond. I'm going to ask the jail to give you a notice for your court date. Will it be April 7th still?
Yes.
April 7th will be your court date, Mr. Lee. They'll give you that notice in just a few minutes, and then you'll get to use the phone. Do you have any questions, sir?
No, sir.
Mr. Lee, wish you the best.
Yes, sir. Thank you.
Yes, sir. We have James Levins next. Mr. Levins, good morning. Mr. Levins, you're here for charge of violation of state probation in case 24-074. The warrant that I'm looking at is a no bond warrant signed by the circuit judge. It's based upon a new charge in Calhoun County, it appears. Mr. Levins, I'm going to appoint the public defender's officer to represent you in this VOP if you want one, if you want an attorney, that is. Would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions in just a minute.
Your Honor, we're going to plead not guilty. Yes, it's the April 23rd court docket, and I advised him there'd be an attorney from the PD's office that come by and talk to him for the hearing.
Thank you, Mr. McDaniel. Mr. Mitchell, anything?
No, Your Honor.
So Mr. Levins, attorney will see you before your court date. Do you have any questions?
No, sir.
All right, sir. Wish you the best.
All right, thank you.
Yes, sir. Stephen Cooper. Hey, Mr. Cooper, good morning. You're here because you've been accused of one count of, good morning. You've been accused of one count of violating a pretrial release condition for domestic violence. That is a relatively new statute in the last few years, I think. That's a first degree misdemeanor that you're accused of. You're already on bond in case
26132 MM.
26132 MM for about 3 days. I think you've been on bond about 3 days, and now you're accused of having contact with the alleged victim in violation of a court condition of your bond. So that's what you're accused of. That's your bond status. I'm going to listen to the attorneys, and then we're going to go from there. Mr. McDaniel, anything on behalf of Mr. Cooper?
Your Honor, just that he, denies allegations, but that's all.
Thank you. Thank you, Mr. McDaniel. Mr. Mitchell?
Your Honor, I guess I could elaborate on some more information regarding this. I know that this complaint is an allegation about incidents and that may have happened when he was out on bond. We have been in contact with the victim since basically this case has been filed. And even while he was in custody, there was allegations from the victim saying that he was using third parties to try and get in contact with her. So we have definite concerns about, regardless, even if his bond is revoked, which is what we're requesting, that even if he goes back into custody, if he will follow the rules of the court and, not use any third parties to try and contact the victim. We just wanted to bring that to the court's attention to determine what the right course of action is as it pertains to his phone privileges at the jail.
Thank you. So, Mr. Cooper, there appears on your criminal history, I'm showing 3. Now, sometimes that may duplicates, but I'm showing 3 times you've been charged with violating injunctions for protections.
Only one time, sir.
2015.
I told my daughter happy birthday.
2015 in Okeechobee County, 2016 in Okeechobee County. And then there's another one. When was the other one? So there's evidence that in the past you've not followed the judge's order. 2024 is the other one. There's a contempt of court. So given the evidence against you in this case, I'm going to set you a bond in the new case because you're entitled to one. Your bond's going to be $5,000 cash or surety, but don't try to post it because I'm revoking your bond in 26-132 MM. There is an independent witness that allegedly saw you contacting the alleged victim. So there are 2 people saying this happened. And so that's why I'm doing this. Now this is the 4th time you've been accused of not following a judge's order regarding contact. So you have no bond at this point. Regarding your phone privileges, I think it's premature for me to try to stop your phone privileges at this point, but I am going to tell you how that works, just so you understand. You have normal phone privileges, but if all phones are recorded from the jail. If there's any evidence that you're using that phone to call a third person, and then that third person is calling the alleged victim, and there's communication between you, or if you're using that third person to send messages to the alleged victim, in that event, I typically will revoke all phone privileges except talking with an attorney. So don't go down that path. You need to have no contact whatsoever. First of all, you could be charged with a criminal case called tampering with a witness. You don't want to do that. That's a felony charge. And secondly, you will lose all your phone privileges very likely if that happens. So no contact with the alleged victim at all. That means no contact. That means written, electronic, telephonic, in person, face-to-face, carrier pigeon. I don't care. No contact at all with the alleged victim. And we'll see where this thing goes from here. As far as scheduling goes, what court date, Mr. McDaniel, are you requesting?
Just put them both on the April 8th, I guess, Your Honor.
April 8th will be your court date. Mr. McDaniel is very proactive. One thing's let me double check that date. You think it may be the 9th?
Maybe the 9th. I'm not, John may be correct.
Well, I mean, I don't know.
Okay. So April 8th. So one thing about Mr. McDaniel, he's very proactive. And what I mean by that is he stays on top of his cases. So he may have you up before then. Otherwise, that'll be your court date. You will get to use the phone today. The reason you get to use the phone is you get to contact friends or family, let them know what's going on with your bond status, that you don't have a bond right now in one case. Mr. Cooper, do you have any questions?
No, sir.
All right, sir. I wish you the best. We have Diana Burns. Ms. Burns, good morning.
Good morning.
Ms. Burns, good morning. You're here because you've been accused of one count of driving while license suspended or revoked. Knowingly, Ms. Burns, there is probable cause in the complaint, ma'am. Excuse me. I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel.
Your Honor, I talked to Ms. Burns. She's going to plead of no contest to charges listed. The understanding is she will be placed on probation for 6 months, $400 fine. She gets her license back. I think she's mailed off the ticket that she owed, so she should have them back hopefully here pretty soon. The fine will be $300. She has waived the right to a jury trial and call witnesses and just resolve this case today.
Thank you. Ms. Burns, you need to understand a couple of things, that you have 60 days to get that reduction in the, so if you get your license within 60 days, it'll get lower, like Mr. McDaniel said. The other thing is these cases all have a condition that you not drive a motor vehicle without a valid license.
Yes, sir.
And you get a license if one is reasonably available to you. Knowing all of that, is this the plea you would like to enter, ma'am?
Yes, yes, sir.
And Mr. Benson is agreeable with the state.
It is, Your Honor.
Ms. Burns, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly, withhold adjudication of guilt, sentence you to 6 months probation with the standard conditions of probation plus the following special conditions. Ms. Burns, those are $400 court costs and fines, obtain a valid driver's license if one is reasonably available to you, do not operate a motor vehicle without a valid license, and if you can get a valid license within the first 60 days, I'm going to save you $100 on your court costs and fines. They'll be $300 instead of $400.
Yes, sir.
Ms. Burns, what's going to happen next, ma'am, is they're going to let you get dressed in your regular clothing. They're going to let you use the phone at the jail. The reason for that is in case you want to contact friends or family, ma'am, for transport purposes. You can be picked up, not at the jail. You can be picked up at the courthouse in probably 30 to 45 minutes. That's about how long it takes you to get dressed, to get you here, get you instructed by the probation office, and you'll be free to be picked up. If you want to call someone, you certainly can do that.
Yes, sir.
Ms. Burns, do you have any questions?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Thank you. So for first appearance, that's it. I've got two other things I need to ask you about, gentlemen. Let me see if we got court anything else.
Short morning for Judge Wade Mercer. Good morning, everybody. TCF Live. Good to have you all with me today. I think maybe I've only been to this court one other time, so let's give it a look. This is Judge Rossi, 17th Circuit of Kent County, Michigan, one of my old stomping grounds.
Plea. So at this time, I will let Ms. Burks lead us off.
Thank you, Your Honor. It's my understanding that defendant will be pleading guilty to assault, strangulation. In this case, well, actually, he'll be pleading no contest. In exchange, the people agree to a dismissal of the supplemental information. Here, defendant is a sup 2. In addition, there has been further negotiations by Mr. Lockman that provided that the defendant completes a period of probation. Let me clarify, the people are not recommending no jail, but if there is jail time ordered and then probation after, if the defendant completes that probation and counseling, treatment, whatever necessary, the people would be amenable to reducing this to an aggravated domestic violence, depending on his participation and completion of probation.
And would we accomplish that via a delay of sentence, or would that be accomplished via sentencing with the additional term, and then we'd simply go through and do the set aside?
The latter of what you just said, Judge. So you would, the people would propose that you would sentence and then set aside.
Very well. Okay. All right. Thank you, Ms. Burks. All right. And Mr. Gears, will you place your appearance on the record, please?
Sure, Your Honor. Brent Gears on behalf of Mr. Seneca.
Very good. And Ms. Burks, I forgot to ask the maximum penalty for the charge pled no contest to today, the strangulation charge.
That is 10 years, Your Honor.
Okay. Very good. Thank you. All right, Mr. Seneca, I'm going to swear you in and proceed from there. So, Mr. Seneca, if you could raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do, Your Honor.
All right, thank you, Mr. Seneca. And Mr. Seneca, you understand that maximum penalty I could impose on the assault with intent to do great bodily harm by strangulation in this matter would be 10 years in the Department of Corrections.
Yes, Your Honor.
Okay, and you've had the opportunity by now to go over the rights you're giving up by entering a no contest plea in this case with Mr. Gears.
Yes, I have, Your Honor.
And you understand that includes the right to be tried by a jury and, of course, to be presumed innocent till proven guilty and placing the burden on the prosecutor to prove beyond a reasonable doubt that you are guilty?
I do, Your Honor.
And you also understand you're giving up the right to have the witnesses against you appear in person at the trial and testify and be cross-examined by Mr. Gears, as well as the ability to have Mr. Gears subpoena in witnesses that would testify in your favor and have them appear at trial. You understand you're forfeiting the right to have the witnesses appear.
I do, Your Honor.
And of course, during that trial, you'd have the right yourself to either testify or to decide not to testify. And I would instruct the jury not to hold your silence during the trial against you. You understand that, right?
Yes, I do, Your Honor.
All right. And finally, there is an impact of a plea entry on appeal. If you appeal after a trial, the Court of Appeals must review my decisions before and during the trial by right. That is, you have an appeal of right. They have to review everything that I did. If, on the other hand, you appeal after a plea, it is by leave, and that means you basically need to convince the Court of Appeals that your arguments have enough merit to be reviewed in the first place. It adds an extra hurdle to any potential appeal. Do you understand that, Mr. Seneca?
I do, Your Honor.
Very good. And Mr. Seneca, did you understand the plea agreement as it was stated by Ms. Burks?
Yes, I do, Your Honor.
Okay. And that sounded accurate to you?
Maybe I should say, to clarify, she said that the latter of the two would be that.
Yes, I can clarify that for you, that I will sentence you then on May the 21st to a sentence that will be to the felony charge. If you successfully complete the period of probation that I would undoubtedly impose in this case, it could be anywhere between 1 and 3 years. Then the prosecutor agrees then to, in a separate proceeding, set aside the felony conviction and enter a misdemeanor conviction, again, contingent on your successful completion of the probationary period. Is that consistent with your understanding?
I was wondering if the current probation I'm on, if that finishes, or is this, you're talking I'll be sentenced and
There
put
will
on
be a new
probation?
period of probation. Yeah, are you on probation
Okay,
on
that I
another
did
case? Are you on another case on probation, Mr. Seneca?
Yes, sir. It's a OWI case, and that's what I
okay.
thought that I was
Yeah,
completing.
this will be totally separate.
Okay.
Is that consistent with your understanding, Mr. Seneca?
It wasn't, but I do understand it now.
Okay. Do you feel like you need more time to discuss with Mr. Gears, given the new information?
Maybe I understood it from him wrong. I don't know if he's got a.
Well, and I did want to interrupt here a moment. I thought this was going to be a delayed sentencing situation. So I'm not sure how we can accomplish the set aside formally, other than through a delayed sentence.
Well, the significant difference as I see it is, the judicial, it really involves, though it is an important criminal procedure distinction, that there is a little bit more hurdle in setting aside that there has to, and the fact is that a felony conviction during the period of probation, I kind of deal with this frequently in treatment court, does enter and is sentenced on. So, in terms of a record that might be entered in lien, for example, it'll look like for that period of probation that he's been fully convicted of the felony offense. Now, at the end of the felony offense, you can go through, prosecutor files a motion to set aside the original felony conviction. I set that aside, and then we take a plea to the lower offense at that time and enter the misdemeanor conviction as the outcome after after probation. So it can be done. It's a little more complex than perhaps the delayed sentence, but it still accomplishes, I guess, the same goal at the end of the day.
So does that clarify, Mr. Seneca? I mean, it's the same outcome that we discussed. Essentially, it's just a different way of going about it.
Okay, then yep, I'm good, and we can proceed.
Very good. All right. So that sounds accurate to you as well, Mr. Gears?
It does, Your Honor.
All right. And back to you, Mr. Seneca. Mr. Seneca, has anyone offered you anything in exchange for a no contest plea today that we have not talked about during this hearing?
No, Your Honor.
No one threatened you to get you to take the no contest plea?
No, Your Honor.
So your decision to plead no contest is your own choice?
Yes, it is, Your Honor.
Okay. And how are we going to establish the factual basis, counsel?
I will do so, Your Honor.
All right. Thank you, Ms. Burks.
This is based on Kent County Police Report number 25-130020, which states that on or about May 29 of 2025 at 1354 Glen Park Drive Northwest in Kent County, Michigan, the defendant did commit an assault by strangulation against Rose Noreen Hill, in that he put his arm around her neck and dragged her with her neck in the crook of his elbow. She started struggling to breathe and found herself unable to call the neighbor's name out for help. She tried, but wasn't able to. She stated this lasted about 10 seconds and she couldn't breathe at that time with his arm locked around her neck.
All right. Is that an adequate factual basis or an accurate factual basis, Mr. Gears?
I believe it supports the plea, Your Honor. Yes.
Okay. And Mr. Gears, are you aware of any threats, inducements, or promises made to Mr. Seneca but not placed on the record?
I am aware of none, Your Honor.
Ms. Burks, are you aware of any threats, inducements, or promises made in this matter that we haven't talked about on the record?
No, Your Honor.
Now, have I followed the court rule, Ms. Burks?
Yes, Your Honor.
And Mr. Gears?
The court has, Your Honor.
Very good. Then I will accept the no contest plea. I find it accurate and supported, I find it voluntary and supported by an accurate factual basis. I will have Mr. Seneca, you should contact probation immediately following this hearing so that you can participate in an interview for your pre-sentence investigation report. And I will have that PSI completed at least 1 week prior to sentencing, which I will set for May the 21st of this year at 9 a.m. in my courtroom. And bond conditions to remain the same, Mr. Seneca, including a very strict no contact with the victim. The prosecutor's office informed me that the victim at least perceived that there was a Facebook post that was directed at her by saying along the lines of, look at this sweet deal I got. That's kind of in your face. Now, I know the nature of electronic media posts and things like that. That may not have been the message you intended, nor may it have been directed at the victim. It may have been in some other context. However, I will inform you, Mr. Seneca, that the definition of contact that I impose to enforce a no contact order is the one contained in Michigan law, which basically says any electronic communication, even if it's directed to another person or posted in a completely different forum, if I decide the intent was to convey a message to your victim, even if that message is, look at the good deal I got in the criminal case or whatever it might be, the law places the advantage here squarely with the victim and the disadvantage squarely with you. And further, this diversionary type sentence you got in this matter, even though it's not a formal domestic violence diversion, is a good deal. And if you do violate that, then that deal falls out from under you, and I will sentence you on a 10-year felony which could land you in the Michigan Department of Corrections. So as I say to many people who are subject to a no contact order in circumstances like this, you don't want to send any message, be it by mail, carrier pigeon, smoke signal. I don't care how it's sent. If it goes and the victim reads it and comes in front of me and says, I think this was directed at me or some such thing, and I agree with the victim, you got everything to lose in this case. Am I clear on that, Mr. Seneca?
Yes, Your Honor, I was not aware of any such
Okay, well,
post.
Mr. Gears can maybe inform you a little more about
Okay.
what that was, but like I say, you just totally need to refrain from anything like that. And as I said, the downside of social media, of course, is if you send a message to one person, you have no idea what that other person might be putting it on their public post. They may be reconveying it. A lot of times in a situation like this, you think that person is on your side, and in reality, they're communicating everything that you say to them directly to the other party. And, like I say, you don't even want to get into a situation where I'm examining those facts, in 20 minutes before the hearing and then deciding on whether to send you to prison or not. The stakes are just simply too high to mess with it. So, very good. And I'll give you a breakout with Mr. Gears. He can explain what he understands of that allegation. I just got a verbal notification of that from the prosecutor. I don't know that much more about it either, but I did want to give you the warning because, as I said, the stakes couldn't be higher in your case.
Yes, Your Honor. Thank you.
Very good. Thank you all, and we'll give you a breakout with Mr. Gears. And like I say, strict adherence to that. And of course, that's going to be one of the terms of probation. So this will be a practice run running up to probation that, you just gotta, completely separate yourself in every way, shape, and form. That means taking a social media holiday for a while. Well, I'd say, as opposed to getting a holiday in the Department of Corrections, I'd take the social media holiday.
I agree, Your Honor.
All right. Thank you.
Thank you.
Okie dokie, friends. Let's head back down to Ohio and Judge O'Donnell, new contestant there.
Our defendant did not report August 14th of 2025 to probation. You understand that charge?
Yes, sir.
Third, positive urine sample on February 17th of this year for cocaine. You understand that charge?
Yes, sir.
We're here for the final hearing. Mr. Roby?
We are going to admit or plead guilty to those violations and offer some evidence in mitigation.
Is that what you want to do?
Yes, sir.
What's your plea to those allegations?
Guilty.
I'll accept your guilty plea and find you guilty. Mr. Roby?
Thanks very much. These are the things that I would say on Jesse's behalf. He's 43 years old. He lives in Chagrin Falls. He's got a very good job with the tree company. I provided some documentation. They still have that job awaiting for him. They have plenty of work. He'd like to get back to work. He has a significant other who's a clean and sober individual. He indicates that prior to turning himself in on February 12th, that he secured an AA sponsor and is more than willing to go and do whatever the court asked him to do as far as meetings. He's had 36 days in the county jail to think about it. His head is cleared. He does have some health. Well, I think I shared with you about his father. His father is failing, is in stage 4 pancreatic and lung cancer. He'd like to be able to get back to his father. If I can approach, I have some medical documentation as far as Jesse that talks a little bit about his condition. He's unable to keep a lot of weight on, so it's been quite a difficult stay in the county jail. That kind of his doctor talks about that. So I would ask the court if it would consider releasing him, giving him again the privilege of community control. If the court wishes to extend it, I don't think we'd have an objection on that. And attaching conditions, whether that's an outpatient program or AA meetings. He'll do whatever he needs to do in order to try to get himself back together. Thanks, Judge.
Thank you. Well, trying to think what I could order him to do that he would actually listen to and do. Sit down. You were sentenced on June 5th of 2025. You were given an additional 40 days in jail. So that gets you out about July 10th after you did the jail treatment program, right?
Yes, sir.
Okay, so you got out on or about July 10th after having completed that. And 2 weeks later, you submit a urine sample that's positive for cocaine. Why is that?
I was young and dumb, my mind wasn't clear.
Wait a minute. On July 24th, you're 42 years old. Now you're
Yeah.
43, so you're not young and dumb.
Right, yeah.
Okay, that's a
Just dumb.
that's a horseshit reason. Okay, so you just what'd you do? Stare at the wall during the jail treatment program, bide your time, do whatever you had to do, and get the hell out of there?
No,
right?
sir.
Yeah, I mean that's what you did. Why did you then disappear?
I can't give you any excuses of what I did in the past.
I'm not looking for an excuse. I'm looking for an answer as to why you disappeared.
My father had hip replacement. My mom needed my help, and I wanted to take care of my family. And once he was able to help himself a little more, then I could turn myself in and do the right thing.
Okay. And did you talk, so when is the first time after, how often was he reporting, Dave, or Josie?
Sir, he only reported once until he disappeared.
And when was that?
That was on the 24th of July when he reported and tested
Okay.
positive for cocaine.
All right. And who was the PO? Were you the PO, Dave?
I was not.
Who
No,
was?
it was Jennifer Harris.
Okay. So I presume you told Jennifer Harris about this family situation that was going on and how it was going to be difficult for you.
No, sir, I didn't. I was afraid.
Why not?
I was afraid too, sir.
Afraid of what?
I was afraid of the consequences.
No, you weren't afraid of the consequences. Did you? Did he have a discussion with you, Josie, about why he didn't show up? What did he tell you?
Your Honor, he told me that he wanted to ride his motorcycle with his father and do cocaine and didn't want to ruin his summer being in jail.
That doesn't sound like anything I would say.
So you didn't say, when did he tell you that?
That was on February 17th.
Okay.
I wouldn't say
Were you
that.
just meeting with him? Was it-
Yes, Your Honor.
Okay. You didn't tell that to her?
I wouldn't tell her I wanted to do cocaine, that's for sure. I wouldn't say that to
Why is
anybody.
she lying to me?
I have no idea.
Okay, well, she's not lying.
I mean, I do want to ride with my dad since last time, being able to ride on a bike. That's why I turned myself in to do the right thing. So I
Didn't
could
want to
get my-
ruin your summer?
No, I wanted to get my life back on track. That's why I turned myself in, do the right
I
thing.
thought the point of the terms of probation was to give you the necessary tools, I hate that word in this context, but the necessary tools to get your life back in order.
Right.
Wasn't that what it was supposed to do?
Correct.
Okay, so why didn't you take advantage of the tools?
I had family problems and.
What?
Had family problems and had to take care of my family,
By riding around doing coke?
I didn't have my license. I couldn't drive anything. I haven't even drove my car.
So you weren't riding around on your motorcycle?
I don't have a license.
I know you don't have a license. Half the people out here driving every goddamn day don't have a license, okay?
Yeah.
So are you telling me you weren't driving at all during this time you were gone?
No, I wasn't driving the whole time.
You were not driving?
No, sir.
Okay. Why do you insist at this point, where you are right now, why do you insist on lying to me?
I'm not lying to you,
You're not.
sir.
And I suppose the next explanation you're gonna give me of testing positive in July and then February is you only used cocaine twice.
No,
No?
no.
How often were you using it?
I was using it every other day.
Every other day? Okay. Well, why should I keep you on probation? Why in the world would I keep you on probation?
Because I'm trying to do the right thing. I turned myself in. I had a lot of time to reflect from my time in jail. I got my head on straight now. I want to become a member of society and do the right thing.
I'm supposed to believe you.
I would hope so.
I don't believe you. Why would I believe you? Okay? I believed you on June 5th of last year. That's why I put you on probation and tried to give you the tools. Okay? Where'd you get your mental health evaluation? You didn't, right?
I went to Dr. Lott.
Who?
Dr. Lott University Hospital.
He did a mental health evaluation?
I believe so.
You mean the Dr. Lott who wrote that
I had a lot of head injuries.
you've got this condition
And
that affects your system as to being able to keep weight on and the frequent eating you need to do?
yeah,
Okay. That Dr. Lott gave you a mental health evaluation?
I can't recall. I mean, I know JTP, they gave me a mental health
Okay.
evaluation.
No, they
too.
didn't. Okay. So what did Dr. Lott say about every other day using cocaine as far as your medical condition?
He told me not to.
Okay. So you don't listen to him either. Who do you listen to? Who do you listen to?
I'm listening to you.
No, you don't listen to me. That's why you're here, because you don't listen to me. You don't care what I have to say. What I say has no effect on you, so why in the world would I keep you on probation?
Because I want to do the right thing.
No, if you wanted to do the right thing, you would have taken some corrective action after July 24th. Corrective action wasn't disappearing.
That's why I turned myself in. I wanted to do the right thing.
You disappeared July 24th, and you turned yourself in February 17th, and you think you want some sort of credit for that, for doing that?
No, my father had a hip replacement, and I wanted to help my father.
Why don't you have a driver's license?
Because the courts kept it, and I didn't get to renew it.
What courts kept it?
This one.
This one. I suspended you for a year,
Yeah, I didn't.
effective September 25th of '24. So how am I keeping your license from you?
Well, the warrant for my arrest has the hold on my driver's license, and that.
So you chose to do that. I didn't. I've got nothing to do with your suspension.
Right.
So why don't you have a license?
Because I had a warrant out for my arrest.
Yeah. And you had a warrant out for your arrest because you decided you didn't want to play in the whole probation thing. That's why you had a warrant out for your arrest.
Right.
Right. So why don't you have a license? You don't have a license because you decided it wasn't important to get a license. You decided it was important to run around doing coke every other day. That's your priority. Your priority isn't your mother and your father. Your priority was you getting high every other day.
Well, I've changed my mind, and I had a lot of time to think about it.
Maybe you need more time to think about it. Maybe you need 12 months in prison to think about it. That seems to be what you need. Okay? I mean, you want me to put you on probation, and you blew that off within 2 weeks, if it was even that long. And you want me to do that again? What is it that you think you can accomplish on probation?
I could turn the page, sir.
What does that mean? I don't know what turn the page means.
I could do the right thing.
I don't know what do the right thing means either. Because you've demonstrated that you can't do the right thing.
Not to use drugs.
So what is it don't give me these platitudes, okay? Don't listen to what the knuckleheads over here are saying, okay? What is it you need to do on probation?
Just to not do drugs and can, yeah.
So how do you propose to accomplish not doing drugs?
Staying away from people and places.
What people were causing you to use drugs in the last 9 months?
It was, people I chose to be around at that point in time, sir.
What people?
People that did drugs, sir.
Who?
Drug people.
Drug people?
Yeah.
You were doing drugs with drug people. Who? What? I don't know. That's why I'm asking you.
Yeah.
Friends.
Friends.
What friends?
Some friends that I don't need anymore.
Okay, which friends are those that you don't need anymore?
I can't recall.
You know, I don't have any more hearings today. I can do this all day. All day I can sit here and ask you questions, and all day you can give me non-answers, and then I can do this all goddamn day if you want. Or I can say 12 months and get up and leave and take the rest of the day off. Those are my two options. I'll tell you what you do. Why don't you take a few minutes, talk to Mr. Roby.
Thank you.
Who's doing his best to help you, and then I'll come back.
Yes, sir.
All right.
Yes, sir.
Okay.
Okie dokie, friends. I will keep an eye for when he comes back. In the meantime, let's go back to Judge Anzalone.
Okay, so this is in the matter of the people of the state of Michigan versus Timothy Jerome Neves Jr., file number 25-2222 FC. I have Michael Dagger Margosian appearing on behalf of Mr. Neves, and I have Alexander Bayonetto appearing on behalf of the people. Mr. Neves is present in person for sentencing. So this is the date and time set for sentencing. Mr. Neves, did you have a chance to read and review the pre-sentence report?
Yes, ma'am.
Okay, so Mr. Dagger Margosian, again, I apologize for the recording system in our courtroom, but your client is soft-spoken, and so if we don't pick you up, we may need you to stand at the podium. So, Mr. Neves, you don't usually get to yell in the courtroom, but you can be loud today, okay?
Yes.
Okay, so you got a chance to read the pre-sentence report?
Yes.
Okay, you picking it up, Ms. Spade?
It's fine, thank you.
Okay, and you had an opportunity to discuss that with Mr. Dagger Margosian.
Yes.
Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes.
All right, Mr. Dagger Margosian, well, first, Mr. Bayonetto, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, no.
Mr. Dagger Margosian?
Nothing in the body of the report.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I do show that he has 11 prior misdemeanors. Mr. Bayonetto?
I don't believe there are any errors.
Mr. Dagger Margosian?
No challenges at this time, sir.
All right, the probation department has computed the minimum sentencing guidelines to be 135 months to 225 months. Do you agree with that calculation of guidelines, Mr. Bayonetto?
Your Honor, the way I have the guidelines scored, we do still end up there. However, I think there are some of the PRVs and OBs that I know I would like addressed. We have.
So let's slow down a little bit. So we're going to start, which is your first one?
Your Honor, we do have two that are being stipulated that they should be 0, PRV 6 and OB 17.
Okay.
And then I guess I could start with OB3, I believe should be scored at 25, and I can argue whenever the court feels that's appropriate.
So Mr. Dagger Margosian, OB3 is prosecutor thinks should be scored at 25.
I think it should be scored where it is at 10.
All right, so let me pull up the OBs. Right, OB3 is scored for a physical injury to a victim. It is currently scored at 10 points. Bodily injury requiring medical treatment occurred to a victim. And Mr. Bandetto's arguing it should be scored at 25 for life-threatening and permanent or incapacitating injury occurring to a victim. So. Right, and the basis, Mr. Bandetto?
Yes, Your Honor. And this is actually a case that's cited to in the guidelines, annotated guidelines manual. Your Honor, 25 points is appropriate when there is permanent incapacitating injury that had occurred to a victim. The case that I'm referring to that's cited in the manual that Your Honor is referencing is People v. Parks. While that is an unpublished case, I think it is very relevant in the facts in this case. In that case, there was a shooting that had happened. I believe the conviction was for assault with intent to commit murder. And in that case, 25 points was scored, and it was appropriate because the victim, 7 months after the shooting, the judge could see that he was still incapacitated from that shooting. The court noted in the opinion that the victim in the case struggled to navigate the courtroom because he had to walk with a cane and was still having to go through rigorous therapies and things like that. That case defines incapacitate as to deprive a person of their capacity or natural power to accomplish the things in their daily life. Your Honor, you heard the testimony from Ms. Hopkins at trial. She did indicate that she was off work for nearly 11 months. She had to have multiple surgeries. She's still to this day undergoing physical therapy. And I believe when she was testifying, she actually showed the court that she cannot fully close her hands still. She does not have regular, the motions that she had with her arm. I believe she testified this whole portion of her arm is still numb. She doesn't expect to ever get feeling back in that. You know, because she still is undergoing the effects of the of Mr. Neves stabbing her repeatedly in the arm. She cannot close her hand adequately. I would argue that that is permanent incapacitating injury, which would make 25 points appropriate in OB3.
Mr. Dagger-Markosian.
Judge, obviously, to address the first portion of the 25 scoring, whether it's quote unquote life-threatening, I think it's by definition what the EMTs testified to at trial. It was necessarily not life-threatening. So moving to the permanent incapacitation, yes, there is going to be residual injury and residual PT that a person has to go through with an injury like this, but I think it's beyond speculation for the state to say that she's never going to recover the ability. It may, whether she's probably going to have to continue PT. In the case that Mr. Bayonetto cited unpublished, the individual had issues walking up to the stand. Well, there was nothing like that in this case. Again, I'm not I think it's important in a hearing like this to separate the conviction, the conduct that led to the conviction versus how we score properly. So that's, I want to obviously focus on the scoring portion of this. The victim here at trial did not have any issue with mobility. She didn't have any issue with any other sort of permanent incapacitation. So again, I think with the way that Ms. Holly has scored this, it is appropriate at the 10 points. So I'd ask the court to keep that.
Okay. So we did have a bench trial in this case, and the victim in this case did testify in depth about the incident that occurred. He had her on the ground, he held her, with his left hand, and he had a knife. He put the knife to her throat. He tried to slit her throat, but she was holding the blade, cut her hand. He started stabbing her. He hit her twice in the neck, and once in the back. As she got up and under her arm, she suffered cuts and damage. Her daughter came into the room, kicked the defendant. Eventually, he let go of her and she was able to get up. Testimony was that she has limited use of that arm and she had multiple surgeries and physical therapy. And People v. Parks, as referenced by Mr. Bayonetto, it is an unpublished case dated or issued February 18th of 2021. The 25-point scoring is appropriate for permanent incapacitating injury where the victim suffered continued impaired mobility more than 7 months after the shooting, requiring use of a cane to walk. Obviously, she didn't need a cane in this case, but she did testify to continued impaired mobility. This incident occurred back on February of 2025. Let me double check. I think it was February of 2025, and the bench trial was February of 26. So that was well over 12 months. So I do believe that OB is probably, or should be scored at 25. So I will grant that request. Do you have any others, Mr. Bayonetto?
Yes, Your Honor. I believe OB4 should be scored at 10 points, and I can argue whatever.
OB4 is currently scored at 0 for psychological injury to the victim. And you're asking for 10 points?
Yes.
All right. Mr. Dagger-Margosian.
Your Honor, I believe it's properly scored at 0.
Your basis for your request?
Ms. Hopkins, I think, touched on it in the statement that she provided to the court this morning. However, I would again point back to her testimony at the trial and the emotions that she showed at trial. And I apologize, Your Honor, I can't recall if she had testified to whether or not she was in counseling at trial or not. She does say in the impact statement that she has undergone extensive counseling as it relates to this incident. However, that I don't think is dispositive in and of itself, Your Honor. As the guidelines manual repeatedly points out, that going to therapy alone is not dispositive one way or the other. You could not be in therapy and still have serious psychological injuries. I would submit her testimony at trial really showed what this incident, how this incident has affected her. Especially, and I would say any person that has to go through as brutal and violent an assault as she did, I think that is completely an appropriate reaction. So given the fact that one, she is in counseling, and coupled with her testimony at trial, I think 10 points would be appropriate for psychological injury requiring professional treatment as so before.
All right. 10 points, reference People v. Schraben, 314 Mish App 181, 10 points properly scored for OB4 under the preponderance. Is that the one we're on, OB4?
Yes, sir.
For OB4, when the victim had written a letter to the court stating the last 3 years have been a struggle psychologically. We do have a victim impact statement which states that she's involved in rigorous therapy sessions and is still involved in them. Specialized visits and continuous appointments to combat the trauma sustained are essential. So I do feel OB4 is properly scored at 10 points for serious psychological injury requiring professional treatment occurring to a victim.
I'll just, for record purposes, state my objection to it. Under People v. White, it does list a very high threshold for an individual to qualify for OB4. And an individual simply going through this offense does not necessarily by itself qualify for 10 points under OB4. The victim in this matter was able to testify cogently, coherently at the trial. So again, with the circumstances of the offense itself, I don't believe that it would meet the high standard for OB4 to be scored at 10 points.
Well, the testimony along with the body cam videos and other testimony at trial, it would seem reasonable that her fear that she was bleeding out, her statements made in the video and calls to 911, as well as continued psychological counseling would merit that score. But I appreciate your objection on the record. Thank you. Any other?
Your Honor, does the court want to go in order as far as OVs? I think Mr. Dagger-Margosian wants to challenge OV5.
Okay, so hold on, let me get to OV5. Mr. Dagger-Margosian, OV5, you know, this is a pretty serious offense, so I do think it would have been appropriate to have sentencing memorandums filed ahead of time so that the court could have prepared these. Do you want that opportunity in light of the sentence your client's facing to prepare?
No, Your Honor, I think the fact that we are all members of the court right now are familiar with the facts, I think we can move forward.
Okay, so OV5, psychological injury to a member of victim's family. So Mr. Dagger-Margosian, OV5 is scored at 15 points, and your objection?
Your Honor, I believe that should be scored at 0 points. I suspect that the individual referenced in OV5 would be the victim's daughter who did testify at trial. Again, she was coherent, she was cogent, she was able to testify with specificity regarding this incident. On just a layperson observation, she didn't seem like she was that she required any sort of counseling or had any sort of psychological injury. She testified how she conducted herself during the incident, which was clear mind. So I sort of similar to the OV, to my challenge to OV4, the people have not satisfied the high burden of her that she had psychological injury that importantly required professional treatment. So I believe that should be scored at 0.
Mr. Banetto.
Just briefly, Your Honor, and while not, I think explicitly stated in the victim's impact statement that the counseling was for Ms. Hopkins and her daughters. However, as I said in my argument in OV4, even if the court does not find that alone it satisfies by preponderance of the evidence that serious psychological injury occurred to Isabel, I would again point out her testimony at trial certainly does. It was some of the most powerful testimony I think I've ever seen in this courthouse. Isabel very clearly laid out that she's not been able to go back to the house, exactly everything she was feeling as it was happening. But I think it's also important to point out, Your Honor, that Isabel wasn't the only child of Ms. Hopkins that was there. Monroe, who was, I believe, 7 at the time of the assault, also witnessed Mr. Neves repeatedly stabbing her mother. And as the court saw in the body camera footage, Isabel had to carry her little sister out as she's sobbing in her arms, covering her eyes so she doesn't have to see her mom potentially bleeding out or all the carnage from the assault. So I think that the scenario is very clearly harming those children psychologically. So I think 15 points is appropriate.
Anything else?
No. Yeah.
So this is a tough one. Her daughter did testify at trial and she did an amazing job. She was very matter of fact. She was very forceful in her testimony. She did not, during her testimony, address any psychological injury, even though, you know, it may or may not have existed. She did not address it in trial, and I don't have a victim impact statement from her or addressing those things. So I am not going to score OV5. In People versus Portellus, 298, Mich. App 431. The court there scored 0 points, where the grandparent of a deceased newborn submitted a sentencing letter. It spoke about disbelief, grief, anger, heartbreak. They didn't score it in that case. In this case, I don't have a victim impact statement or any indication. I mean, I guess you could assume she does, but I don't have anything that through trial testimony or today that would indicate that. So I am going to leave OV5 or OV5 at 0. I'm going to score it at 0. OV, next one.
Your Honor, I'd like the court to take a look at OV6. It's currently scored at 25 points. I think perhaps 50 would be appropriate. I can make arguments as to that. If that's appropriate.
OV6, offenders intent to kill or injure another individual. OV6 is scored only for crimes against a person and only if the sentencing offense is homicide, attempted homicide, conspiracy, or solicitation to commit a homicide, or for offense committed on or after October 1 of 2000, assault with intent to commit murder. So I think we could all agree OV6 is applicable to this statutory offense. It is scored at 25, which means the offender had unpremeditated intent to kill, had the intent to do great bodily harm, or created a very high risk of death or great bodily harm, knowing that death or great bodily harm was the probable result. To score 50 points, the offender must have shown that the offender had premeditated intent to kill, or that the killing was committed while committing or attempting to commit arson, criminal sexual conduct in the first or third degree, child abuse in the first degree, a major controlled substance offense, robbery, breaking and entering of a dwelling, and so on. That doesn't apply. So the basis for you wanting it scored at 50?
Your Honor, as this court pointed out, and I think I argued it in my opening and my closing as well, Your Honor, that in order for Mr. Gibbs to have been found guilty of assault with intent to commit murder, we had to look at the circumstances as if the victim had died. And so, Your Honor, had Ms. Hopkins have died, we would have been arguing between first and second degree murder. And I believe that the facts in this case would show that Mr. Neves did have premeditation when he committed the assault against Ms. Hopkins. Your Honor, the sentencing guideline manual references People v. Stainhouse, S-T-E-A-N-H-O-U-S-E. The facts in that case, Your Honor, it was another assault with intent to commit murder case. In that case, the defendant waited for the victim in the basement, struck him in the head and slashed at his neck. After the assault, he made no effort to help the victim, and the assault was unprovoked. I think those facts are very similar to the case we have at hand. While I agree Mr. Neves was not lying in wait at the time, he nonetheless had to get up from the room with Ms. Hopkins, walk into the kitchen, grab a knife, and walk back. Your Honor, as the court is well aware, there is no real definition as to the time frame that would allow for premeditation, but it requires sufficient time to permit the defendant to take a second look. That comes directly from the Stainhouse case, and that this court can look at the circumstances surrounding the assault or the killing to determine whether or not there was premeditation. Your Honor, that some of the facts that show premeditation include the previous relationship between the defendant and the victim, defendant's actions before and after the crime, and the circumstances of the killing itself, including the weapon and the locations of the wounds inflicted. Again, Your Honor, Mr. Neves got up from the bed, went into the kitchen, grabbed a knife, walked back, and began assaulting Ms. Hopkins with the knife. There are so many opportunities to reflect on what he's doing at that point, that this, had Ms. Hopkins have died, this would have been premeditated murder. So I believe that there is enough evidence by at least a preponderance of the evidence standard that shows that Mr. Neves had time to consider the wrongfulness of his actions, nonetheless continued on his course of attempting to murder Ms. Hopkins, which shows premeditation, and OV6 should be scored at 50 points. Thank you.
Thank you. Mr. Dagger-Margosian, response, please.
Your Honor, I guess I take issue with a few of what Mr. Bainetto states in this OV recitation. Number one, at the trial, as here today, I think it's a misstatement of law on how he is describing how a court views the elements of an alien. There are multiple ways, and with the prosecutor indicating that had the victim died in this matter, we would be only looking at it as M1 or M2. That is not accurate. That is not legally accurate. There is obviously also a manslaughter possibility in a circumstances like this if the victim dies. So I want to just make sure that we are working with the full picture of what is on the table legally. As for any sort of premeditation, certainly, first of all, there's a difference of factual understanding of this case. One is that Mr. Neves went to the kitchen to get the knife. One is, as he testified, the knife may have already been in the bedroom. Regardless, a matter of seconds between when Mr. Neves gets the knife and to when the stabbing occurs, that is not premeditation. The knife, he didn't plan this. He didn't think this out. It wasn't a scheme, anything like that. It's almost by definition not premeditated. So again, I would think that 25 points is properly scored for OV6.
Anything else, Mr. Bainetto?
Just the only thing I would say, Your Honor, is the manslaughter had the jury instructions specifically state that if Mr. Neves would have been guilty of manslaughter at trial, he would not have been guilty of assault with intent to commit murder. So manslaughter would not have been considered in this case. He has been convicted of assault with intent to murder. So those would be the two charges that are looked at. So again, Your Honor, I'll just defer to everything else I said as it relates to premeditation.
So this was a bench trial, and I did pull obviously the jury instructions, even though there wasn't a jury, and look through the elements, and they've been referenced. So just for the record, I'm going to put them on the record. The defendant is charged with the crime of assault with intent to murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believed he had the ability. And third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or reduce the crime. In this case, obviously, I did find him guilty of assault with intent to murder. OV6 is scored at 25 points, where he had an unpremeditated intent to kill, which I do believe at the very least he did have, but I don't think that the facts at trial were enough that this court could find today, based on the testimony, that premeditation was involved in this. So I'm going to leave OV6 scored as properly at 25. Next OV.
The only other one we have is Mr. Dagger-Margosian wishes to challenge OV10.
OV10, let me get there. Hope Holly, you're keeping score.
Good trying.
Okay. All right, OB 10, exploitation of a vulnerable victim. Ms. Holly scored OB 10 at 10 points. That the offender exploited a victim's physical disability, mental disability, youth or agedness, domestic relationship, or authority status. Mr. Dagmar-Gozzi, I assume you're saying it should be scored at 5?
Your Honor, I am saying it should be scored at 0 because, and if I may just argue.
Yes.
That I see this scoring often, and I think it's erroneous. Here's the reason. I think anytime the probation department sees that it is a DV relationship plus assault, they score it at 10. But obviously with OB 10, you need the DV relationship, but you also, more importantly, you need the exploitation of the relationship. So to score for 10, the offender, important word, exploited a victim's physical disability, well, that wasn't present, mental disability, that wasn't present, youth or ageness, that's not present, or obviously what they must be honing in on is the domestic relationship, or the offender abused his or her authority status. Mr. Neves didn't have any authority status over the victim. So what the people and probation have to rely on is this domestic relationship. But again, an assault happening during two individuals having a domestic relationship is not enough by itself to score OV 10 at 10 points. It requires an exploitation of said relationship. And here there is no exploitation as far as that I can see. They were in a domestic relationship. It went south. There was an assault. He's been convicted of AWIM, but there is no exploitation of that relationship to be scored.
Mr. Bandetto, anything else?
Just briefly, Your Honor, and I would agree with Mr. Dagmar-Gozzi that really it seems the only part of OB 10 that applies as it relates to 10 points is the domestic relationship part of that scoring. However, and I will also agree with Mr. Dagmar-Gozzi that a dating relationship is not in and of itself enough to show exploitation of a domestic relationship. Where I disagree is that it wasn't just that they were in a dating relationship. It was that he was living with her. He was cohabitating with Ms. Hopkins. And there's a very clear use of his strength to overpower her, given the prior history that they had. So I do think that the facts show that there was a clear exploitation of this domestic relationship. So I think OB 10 is scored appropriately, Your Honor.
So OB 10 was scored by the probation department at 10 points. And obviously the parties were in a domestic relationship and living together. OB 10 points is scored when the offender exploits a victim's physical disability, mental disability, neither of which the victim in this case had, youth or agedness. She was not a minor, nor was she elderly. A domestic relationship, or the offender abused his or her authority status. So in this case, the only way it could be scored is that the offender exploited a domestic relationship. So if I go over to domestic relationship, there's a bunch of case law, People v. Jameson, the court erred in assessing points reflecting a domestic relationship. under OB 10, where the facts were merely that the defendant and complainant had previously dated and had sexual relations, but where they had not shared a domicile or cohabitated. The court concluded a present dating relationship standing alone would be insufficient unless there was cohabitation. So in this case, there was cohabitation. Predatory conduct. And you're saying, Mr. Dagger Margosian, it should be scored at 0.
I believe it should be scored at 0. Yes, Judge.
Predatory.
And can I just add one thing? It's just in the instructions under OB 10, the mere existence of one or more of the factors described in 777.40 is not automatically equated with victim vulnerability. Whatever it's worth.
Well, that is correct, Your Honor. People v. Dillard, you are also allowed to consider the difference in the defendant's strength and Ms. Hopkins' strength, even though that is scored as part of the 5-point category.
So People versus McCarrick on the last page, 5 points was scored, and the court said that, or the Supreme SCOTUS said that, or whoever said that the trial court erred in assessing 5 points for OB 10, reflecting a difference in size and strength that was acknowledged to exist between the defendant and the victim, where the offense of a whim was accomplished through the use of a weapon rather than through the difference in size and strength. So it's pretty convoluted in the scoring, but I will score OB 10 at 0. Anything else?
The only other one is Mr. Bennett and I stipulate that OB 17 should be scored at 0. And this is just because if you score something at OB 6, you don't score it for OB 17.
Okay, and Mr. Bannetto did state that. So at this point, I have the PRVs at 15. And the offense variables, 25, 30. OB3, we did it 25. So 55, 65, 90. Did you get 90?
I got 95, but I can recheck it.
Okay,
I
20,
had 90
well, you
as
know,
well, Your Honor.
math, but what is it?
I had 90 as well.
25 for 1 plus 5 for 2 is 30. 25 for 3 takes us to 55. OB4 at 10 is 65. 90, okay. And if we go to the grid, does it change anything?
It does, Your Honor. It takes us to OB level 5, bringing the guidelines down to, I believe it's 126 to, it's somewhere around there. 126 to 210.
Mumble that, say it again.
126 to 210.
Were we changing PRV 6? Because I thought he was on bond for the OWI.
They stipulated that, so.
That case, his probation was terminated and revoked in 2024.
No, there was an OWI that happened in like the same month that this happened. It just happened prior to this.
Right, but he wasn't charged till after.
Okay.
They take forever to
That's
charge
still-
those.
That's down to
15.
15.
Still leaves us in PRB levels.
Okay.
Okay, so. All right, so, so the low end of the guidelines would be 10.5 years now, and the high end of the guidelines would be 17.5 years. Okay, so anything else on guidelines?
Nothing on guidelines.
All right, so at this point, Mr. Brianetto, I believe we have someone who wishes to speak today.
She does not wish to make a statement.
Okay, so the record should reflect I did receive a victim impact statement from the victim in this matter this morning, but the court did have time to review that. And we did discuss some of that while we were doing the sentencing guidelines. The court also obviously was present and heard her testimony at trial. Mr. Brianetto, is there anything you'd like to say on behalf of the people?
Yes, Your Honor. Start by saying the exact same thing I said at the start of my closing argument. That the only reason Megan Hopkins is alive today is because her daughter intervened in the assault that Mr. Neves was perpetrating on Ms. Hopkins. Your Honor, I guess long and short of it is I'm going to be asking this court to exceed guidelines, as I've already argued when we were discussing, I believe it was OV6. Your Honor, had Ms. Hopkins have died, we would be looking at a very different sentencing grid in this. This court has stated that it doesn't believe there's premeditation, and I do accept that ruling. However, I still think a sentence that reflects the gravity and the brutality that Mr. Neves displayed is appropriate. The guidelines, if this would have been murder to go up to 300 months. And I think a sentence that at that range is appropriate. Your Honor, the guidelines in this case do not take into account Mr. Neves' very clear escalations from the prior domestic violence incidents that he has perpetrated on different women. This court heard testimony from Ms. Wolf about the domestic violence incident that she sustained at the hands of Mr. Neves, wherein he did strangle her and assault her. Your Honor, further, Ms. Hopkins also testified to the domestic violence incident with Mr. Neves that occurred prior to this sentencing offense. And in that case, this court saw various pictures, including a boot print that was left on Ms. Neves' back from, or I apologize, Ms. Hopkins' back from Mr. Neves. When Mr. Neves got on the stand, he indicated that wasn't him. However, the court found that was not convincing in this matter and a credible story. The facts of those domestic violence incidents and facts surrounding this case all show that Mr. Neves is escalating his behavior, not maintaining a certain level, but getting to the point where if he does this again, that next victim likely will not be alive. Your Honor, the court can also exceed guidelines based on the defendant's testimony at trial and his statement to the court in the PSI. The defendant in the PSI states that he is taking responsibility for his actions. However, everything else after that shows the exact opposite. He's still stating that and shifting some of the blame to Ms. Hopkins because he feels she was with somebody that night, even though the facts show that they were all together for several hours leading up to the assault. They all being Mr. Neves, John Jaso, Ms. Hopkins' coworker, and Ms. Hopkins. That was really uncontroverted throughout the life of the trial. So the fact that Mr. Neves still wants to shift blame to Ms. Hopkins shows that he really is not taking accountability for his actions. He even asked this court, after finding him guilty of that, to change the charge to assault with intent to commit great bodily harm. That does not show any accountability. And in fact, when he took the stand, he made several statements degrading Ms. Hopkins, saying she had a cum stain on her face, so he didn't want to have sex with her. But then tells Ms. Holly that they did have sex that night. So I see a very clear pattern that Mr. Neves is not taking responsibility for his actions. He's not showing any remorse as it relates to this. So a sentence of 300 months, I think, is very appropriate in this case. At the very least, I would ask the court to sentence at the top of the guidelines, the 210 months or 17 and a half years. This was a brutal attack. The court saw how this has affected Ms. Hopkins. She's still undergoing treatment for her injuries. It saw how it affected Isabel. Isabel has not stepped foot back in that house. She's undergoing counseling. Her grades have slipped since this happened. And the Monroe being carried out by her sister speaks for itself. So I don't need to touch on that. But Your Honor, the sentence in this case should exceed guidelines. It should reflect the gravity of the offense. Again, the only reason Ms. Hopkins is alive is because her daughter intervened. And had she not, Ms. Hopkins wouldn't be here today. I think a sentence should reflect that, Your Honor, and I would ask that the court exceed the guidelines in this case.
Thank you, Mr. Banetto. Mr. Degemark, anything you'd like to say on behalf of your client?
Your Honor, I'm just going to address a couple of things that Mr. Banetto said just a moment ago. Number one, I'm not sure why he keeps focusing on if she died, then this would be the consequence. She didn't die. If she died, he would be charged with murder, and that would be obviously a higher grid and higher offense. She didn't die. It's obvious, but I think it's important to remind the court that we're not dealing with some hypothetical or speculation that Mr. Banetto keeps bringing up in trial as well as at the sentencing hearing. It's the same argument that if a drunk driver, if he or she killed somebody, then they would be facing higher consequences. Yeah, obviously, that's true. But if they don't, then they are sentenced on the conduct that they are convicted of. And here, Mr. Neves is convicted of, by this court, of assault with intent to murder. I will also address something else that Mr. Banetto stated, is that the guidelines or the PSI is not taking into account the prior conduct of Mr. Neves with Ms. Hopkins as well as Ms. Wolf. That's not true. PRV does take into account. It takes into account his prior DV conviction. And so that offense, that conduct is accounted for in the PRVs. And dismissed conduct, I believe, from either Ms. Wolf or Ms. Hopkins, that also is not taken into account for sentencing because there is no conviction. It was taken into account by this court at trial by those individuals testifying to that conduct. So the prior conduct of Mr. Neves with his prior relationships is necessarily accounted for. I will just touch on, I believe, most of what the people have stated today, or at least in part what the people have stated today is it's speculative, it's unfounded. And so with that being the case, I think it's important that we hone in on what was proven at trial, what has been taken into account in the scoring of the guidelines, and what Mr. Neves has done post-incident. Number one, I read the defendant's description of the offense differently than Mr. Bayonetto. And obviously, when an individual exercises their right to have a trial, whether it be bench or jury, they are, by definition, challenging the allegation. So the fact of not being remorseful or taking accountability or acknowledging the conduct, we challenged that factual circumstance at trial. Obviously, this court has made its ruling, but to say that Mr. Neves is not remorseful or not taking accountability or any of that, I think that is viewed differently when it is a trial conviction rather than a plea conviction. Mr. Neves' conduct while at the jail, he's been a trustee. He's had exemplary conduct at the jail. Any of the COs over at the jail would say that as well. Every time I go over to see him, he's well received, well liked. The COs work with him well. He does a great job. As far as the guidelines and what this court will ultimately sentence Mr. Neves to, first of all, I think the notion of exceeding guidelines, I want to be careful in how I say it. I don't want to excuse or minimize Mr. Neves' conduct on the date of incident. With that being said, he's been convicted of an extremely serious charge, one of the highest charges that we have. So you have to look for if there are aggravating factors within the AWIM realm. And I don't see that. He is convicted of AWIM because he stabbed Ms. Hopkins, but there is no, for example, if OV7 had been for torture, that would be a showing that this conduct went beyond and above the conduct required for an AWIM conviction. Or if there was harm to the children, or you could come up with 1,000 examples of where there would be aggravating factors in the conduct. There's not. There was a stabbing that occurred. He left the scene. He was apprehended, and he's now been convicted. That's a pretty, again, I want to be careful how I say this. That is a pretty baseline assault with intent to murder. So taking into account if she had died, if this, if that, it's not what we're here for. We are doing the facts as they stand today. So with the guidelines being 126 to 110, obviously the top end of those guidelines, with this being a Class A conviction, this court has to set the tail end of what that's going to be. And the recommendation was for 180 to 240 months. Under normal circumstances, that would violate the 2/3 Tanner rule. Tanner doesn't necessarily apply because this is a life offense and there is no statutory maximum. However, I think it is probably somewhat of a goalpost that this court has to take into account for deciding what the ultimate sentence is going to be. What I would suggest, and obviously this court will make a determination on what the ultimate sentence will be, but with everything that I've stated, I believe that a sentence directly in the middle of the guidelines would be appropriate. If the court would recall, there was discussion of bottom end of the guidelines had it been a plea. That didn't occur, and that's Mr. Neves' right. But to exceed it after trial could give a hint that there is a punishment for an individual instituting their right to a trial. And obviously, that would not be the court's position to sentence an individual higher than what it would have been without a trial. Now, the court certainly will rely on factors that went into account at trial, and this court is certainly free to do so. So my ultimate request would be that it would be a middle of the guideline sentence, whatever that comes out to.
Thank you. Mr. Neves, is there anything you'd like to say on your own behalf? And make sure, pull that microphone up and make sure you speak loud for me, okay?
And then I want to apologize to your courtroom.
Are you picking him up, Miss Spade? Can you stand here, but. Okay, just speak up a little bit louder. I apologize.
And I want to apologize for bringing this to your courtroom. Apologize to Megan and her family. I am taking accountability for my actions. I took classes. I will take your sentence serious. And appreciate it. And work on my mental health. And just my sincere apologies.
So in this case, the court has reviewed the sentencing report that Ms. Holly put together, and it was very thorough, and it contained the information required. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, report and recommend.
I can't believe it. We get right up to the point of sentencing and she cuts the feed. I can't believe it. You know, I don't get it. Sometimes these judges just do things that are just amazing. So get us all wound up and then just leave us. Ashley, I doubt you'll be able to get it today, but if you could do me a favor at some point this weekend, maybe go on to my courts and see if we can figure out what this guy got sentenced to, and maybe we can share that on Monday. Sorry, guys. No control over stuff like that, obviously. What are you going to do? At first, I thought I'd lost my internet connection because I wasn't looking at it. I was just listening, and all of a sudden it went quiet. But nope, that was her. All right, well, let's go back to Lake County, the continuation of the guy who was in front of Judge O'Donnell.
I suppose I have to make it a condition, if I keep you on probation, to stop hanging around certain people.
Yes, sir.
As you said, drug people.
Friends, acquaintances.
Like who?
The normal everyday people that I would, put myself around.
Okay, we're not making any progress since I left.
People
We haven't made any progress since I left.
Some people I work with.
And that you're proposing to continue to work with?
No, sir.
Well, I thought you worked at Tree Service Now Incorporated.
Yeah, I do other jobs also.
Like what?
Subcontract through other companies that I
How can you possibly climb up and down trees being high on cocaine every other day?
I don't normally use while on the job, on every place.
Okay. So who should I prevent you from hanging around with?
Anybody with family,
Okay.
I mean, if that's what's necessary, sir, then I.
Well, I'm gonna put there a condition that you can't hang around with family?
Oh, my family's my backbone, my support team.
Okay. Is he just not understanding me, or is he just taking the same tack that he took before?
No, Judge, I think that he's taking it seriously. I think it's.
No, I mean, I asked him who I should prevent him from hanging around with, and he keeps giving me everything but the information I'm looking for.
Yeah.
They're not gonna get in trouble.
Ken West and
And who else you partying with?
yeah, and his cousins, Cody.
I wonder if these people really exist, or if you're just giving me names for the sake of giving me names. You know why I'm wondering that? Because I can't trust anything you say.
I understand, sir.
Yeah. Anything else you want to say?
No, sir.
Judge, we did have a conversation. He indicates he does have a sponsor. We've talked about the importance of when those temptations do call, that he knows to contact his sponsor, and they talked about, I think he started to talk about people, places, and things, so.
The people, Ken West and his cousin, Cody. The places, wherever, and the things, cocaine. That's what you've been doing a lot of people, places, and things stuff. How many days has he been in there, Josie?
37 on the violation, Your Honor, 112 total.
You said 37?
Correct.
What medication does his doctor a lot have you on?
What's the medication? Do you know?
Not offhand. I know it's Prilosec, Prilosec 1.
Prilosec.
There's several others that I can't.
How long have you been taking that stuff?
I've been taking it for a couple of years now.
Okay. Is the cocaine just like a supplement for you?
Yeah, it was a
Party drug.
It was a party drug.
I'm always amazed at the guys who have the serious medical conditions and take medication to address the conditions. Figure it's a good idea to mix illicit drugs. Because you see, you want me to be concerned about your medical condition as it relates to you being in jail, but you're not the least concerned about your medical condition. Isn't that ironic?
Yes, sir.
Did you pay your fine yet on that OVI?
Not yet, sir.
Why not?
So I wasn't working at the time.
If you weren't working at the time, how are you affording cocaine every other day?
I did some work, but
Huh?
not a lot of work. I wasn't aware of the fine at the moment.
You weren't aware of it. I told you what it was on June 5th.
I forgot.
Forgot. Well, you didn't intend to pay it anyway. All right, I'm going to extend your community control to June 5th of 2030. So your little game cost you another 2 years on probation. 50 days in jail with credit for 37. Going to get into an IOP, complete it and follow the recommendations. No drugs or alcohol with screens. Not that that means anything to you, but that's a condition. 4 AA or NA meetings a week and a sponsor. You can go to only one doctor, one dentist, and one pharmacy for medication. Take your medication as is prescribed without the supplements. Sign releases, get a valid license. Full employment, get a mental health evaluation and follow the recommendations, and pay the costs and supervision fees. Now, do you intend to do one bit of that?
Yes, sir.
Well, if you don't, guess where the bus is going to take you next time you're here?
In jail, sir.
No, to prison for 12 months. Anything else, Mr. Roby?
No, sir, thank you.
Swyman, anything else?
Nothing further, Your Honor.
Alrighty, friends, let's go down to Texas. We will say good morning to Judge Stevens.
All right. This is class number 25, CR441. You are Tammy Dunaway Judice. Correct. Excuse me. And you were with Mr. Adams, your attorney, and the state's attorney. The earlier you pleaded guilty to operating a motor vehicle while intoxicated, but this is a third-degree felony because you pleaded true to the second paragraph, which included allegations of 4 prior DWI convictions dating back to 2007. And paragraphs 1 and 2 constitute a third-degree felony, so you were facing up to 10 years in prison. The agreement is whatever sentence shall not exceed a cap of 6 years in prison, so you're looking at no less than 2 nor more than 6 years in prison. And you could be convicted, sentenced to up to 6 years in prison. That could be suspended and you could be placed on probation. And deferred or unadjudicated probation is
on what case?
DWI thirds not allowed. So it's a conviction.
Deferred, yeah.
Sir?
You can't do deferred, I don't think.
No, that's disallowed for driving while intoxicated cases. So that's what we are looking at. A pre-sentence report has been prepared. Have the parties had an opportunity to review it, and are there any corrections or changes to it?
I've reviewed it. I don't have any objections, but let me give you this. I wanted to add something to it. I brought this to the probation officer 2 weeks ago, which was a week ahead of the hearing, the first hearing. This was supposed to be heard last Friday, and I brought it 2 Fridays ago, and somehow it didn't get into it, but it's just medical proof that she has a pretty serious osteoporosis, weakness of the brittleness of the bone. She's broken her hip. She's been on a walker. It'll probably be the rest of her life.
But yet she can still drive a 4,000-pound missile.
Evidently, yes. But I said
I haven't been able to, sir, at all.
Since when? Well, we know in October 2023 you were.
No, I mean.
That's when you were caught
Yes.
in the DWI.
But I have not driven since when I had my accident, December.
Of what? 2025, of 2024.
Or 2023, same year.
That's not the real problem. The problem is this is your 5th DWI that we know about. 4. No, man, you got 4 prior convictions. In May 31st, 2007, County Court of Law 3 of Jefferson County, you were convicted to operating a motor vehicle while intoxicated. After that, on August 27th, 2008, which would be a little over a year later, in County Court at Law 3, another operating a motor vehicle in a public place while intoxicated. Then a little over 4 years later, on December 3rd, 2012, you picked up 2 cases. You were convicted of 2 cases in cause number 907764 and 12-15124 out of the 252nd District Court next door. Those were 2 separate DWIs.
Yeah, she was,
that were handled in the same proceeding, but this is your 5th DWI.
yeah, the 4th one, Your Honor, was used to revoke her probation on the 3rd. And that's why they were both the same day.
I know that's still bad.
Yeah,
but here's the problem. This is the problem. She's standing there.
Yeah.
But is not appearing coherent. I know more about her criminal history than she does. This is your 5th DWI, ma'am. You're saying it's not. We got to resolve that first. You should know more about your life than I should ever.
Right.
But why are you saying this is your?
I didn't think it was, sir. That's God's truth.
Well, I think there's some mental problems here.
Or
I think there's some mental problems here. I mean, what's the state say? Or do we have 4 separate prior convictions of DWI?
Yes, Judge, we do.
Okay.
You want me to show them to you?
No, believe me.
But I shouldn't have to be trying to convince you. This is your life.
Well,
you should be more intimately familiar with your mistakes than me.
I know how many times I got arrested.
Ma'am?
I know how many times I got arrested. Arrested.
That's not a conviction. Being arrested, that's probable cause that you might have done something wrong, but you're presumed innocent unless you're found guilty. That's what's important for convictions. It's not a good deal to be arrested for whatever reason. That needs to be fixed, but until you're found guilty, or unless you're found guilty, we're not talking about any other arrests. We're talking about convictions here in this.
Okay.
And that's what sentencing is all based upon, criminal history of convictions and the circumstances of this crime. And it's DWIs that's your only criminal history, but you got, what's that? This last time they gave you a break on your 3rd, you were given a break, you were placed on probation, and then that was revoked with another DWI. And then you were sentenced to 5 years in prison, right?
Correct.
Okay. But you understand the way things happen is when you commit further or subsequent criminal behavior in the same subject matter, the penalties go up. You don't get less punishment for subsequent behavior of the same type. Do you understand?
Right.
All right. I just wish you'd make the right decision when you get into a 4,000-pound missile. It does terrible tissue damage when it hits humans in collisions.
Yes,
we have this every day. We have to deal with tragedies in this room on misuse of motor vehicles. I'm looking at what was presented. I guess, Frank, you presented this from Diagnostic Health.
Yeah, yes, sir. And I gave it, it didn't get in our report, but I brought it to her 2 weeks ago, which is the week ahead of when we were supposed to be here the first time. But it's showing that she does have a pretty serious osteoporosis, or she's had a broken hip and what else?
Broken back, broken shoulder, and broken knee.
And she doesn't walk hardly anywhere except her home. She doesn't go to the grocery store or anything like that. And she'd even be willing to, but even going to probation would be difficult, and she doesn't want probation. What she'd like, Your Honor, and I know it's kind of unusual, is 2 years jail time, and she'd pay a $5,000 fine, and you could even add safe fee. She's never gone to drug treatment or anything ever, or alcohol treatment. She's not an addict, she's an alcoholic.
Well, how do I put her in safe P, substance abuse felony punishment when she goes to prison?
That is prison.
No, that's a condition of probation.
Well,
that's the way we do that. It's safe P is not supposed to be.
Well, she doesn't.
Punishment. It's a medical facility, but that's not a condition under the statute when you get. If they want to send her, if the state of Texas wants to send her to a facility, I guess I can't stop that as part of her confinement, but I can't order it and then place her in prison. But also the problem is, Frank, is it defies logic and the historical significance of the way the criminal system works. You don't get less punishment for the same subsequent misbehavior. That'd be, what kind of deterrence aspect is that? It's supposed to deter people by more punishment each time you make the same wrong choice.
Well, because of her health issues, Your Honor, she's willing, if you give her 2 years jail and she'd voluntarily pay a $5,000 fine only because of her health concerns or concerns for her. That's the unusual circumstance. I understand that each time you commit a DWI, you don't get less punishment.
Well, that's what y'all are proposing. 2 years in prison is less punishment than what we had last time.
But you'll pay a fine of $5,000. Let's pay finally at least make some money.
Here's what's fair is fair. Just because somebody can pay a fine, most people in here can't. So you have money, then you can avoid being held responsible. I mean, if I was a poor person, I'd say, I don't have that kind of money. Why do the rich people get treated differently? I thought that we were all treated fairly under the law.
Well,
and that's the way I kind of believe it should be.
I agree with you, Your Honor, but her health issues are the other factor need to be factored in, and that's why I brought the medical.
Mm-hmm.
And then she's got, she's on a walker. She's got osteoporosis, which is pretty serious thing, and she could just break a bone, not just falling or something.
Okay, but she can still drive a car.
No, not like that. I've been able to drive.
Well, she'd surrender her license if she could,
Okay. Well, we know you were driving one October 19th of 23.
Yeah.
And then after that, you got sick?
I failed.
You weren't ill before that?
No, I failed.
Well, what was? It begs the question. It begs the question. Really, there's a problem when you commit 5 DWIs, man. There's a problem there. And this osteoporosis has just come up after your 5th DWI. How can you explain the misbehavior and the wrong choices?
It was wrong.
How many wrong mistakes do you have to make to do something about it? We even tried to help you with probation, and that was revoked because you got another DWI.
Right.
Wow, probation. Okay. All right.
Okay.
They say.
Looking over the PSI judge, I think what strikes me the most is that the defendant has minimized her responsibility. Until today, it was refreshing a little bit to hear her say, take responsibility. I was wrong.
Okay.
She minimized her responsibility throughout the investigation. Also, the amount.
But she's doing it today.
That's correct.
I guess it's never too late to
Mhm.
make an act of contrition.
Mhm. Also, the number of prior DWIs is a factor. The safety of the community is a factor. The fact that she's already served 5 years at TDC.
What is your?
We're recommending the cap, 6 years TDC, revocation. I'm sorry, 6 years TDC. I don't feel like safety is appropriate in this case. We're going to defer to you, of course, but that is the state's recommendation.
Right. You heard what the state says, and this group of prosecutors has been very fair, I think. She's asking for 6 years in prison. Which- Um, the last time she was on probation, that's let me talk to everybody for just a second.
While we're waiting for Judge, Ashley, thank you for 5 gifted memberships. Lindsay, thank you for 10 gifted memberships. And Barbara, thank you for the $5 super chat. I did not have a chance to thank you verbally earlier as we were in the middle of that hearing that was so rudely cut off by the judge. But thanks to all 3 of you. I really appreciate you. All right, he's taking a bit, and we're a couple minutes in the way back machine, so let me try to push this past his little pause here.
Auto work and the way I do things is that you don't get lesser punishment for the same subsequent misbehavior, crimes. That would not deter crime. That would be working against deterrence. If people know the more they could get in trouble, the less punishment would be. They would just race to make punishments. So your cap is 6 years imprisonment. Anything to add by anybody else?
No, sir.
Anything from you, man? Yes. Okay, then I'm going to find. And I wish this didn't happen. You seem like a nice person, but we're talking about 4,000-pound missiles being driven around,
Yes.
and it's hard enough to drive them responsibly when you're sober, the way other people drive too.
Correct.
You got to be defensive. And again, this is your 5th DWI. You have been a felon 3 convictions ago. I'm going to find you have pleaded guilty in paragraph 1 and true to paragraph 2 in this 3rd-degree felony of operating a motor vehicle while intoxicated. You have pleaded guilty and true to paragraphs 1 and 2 voluntarily, knowingly, intelligently. And you have pleaded true to the allegations in paragraph 2, which state that before you committed this offense, you were convicted of four previous DWIs, 2 of them being felony operating motor vehicles in public places, and you were sentenced to you were placed on probation last time. That was revoked, and you were sentenced to 5 years in prison. The agreement is a cap of 6 years in prison. I hereby find you guilty beyond a reasonable doubt of this third-degree felony. In paragraphs 1 and 2, I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. And I just wish we all weren't put in this position. I just wish you would fix this mess. But you have to know you are a blink of an eye from fatalities when you're operating a 4,000-pound missile, especially intoxicated. And not only you, but everybody else on the road relies on each other to act responsibly with 4,000-pound missiles zipping around the road. And for whatever reason, you did not learn from these prior convictions. And here we are, put into a situation where I'm disappointed, but this is the just result under these circumstances. All right, anything else?
No, yeah.
Okay,
Thank you.
thank you. Good luck, man. Here is this.
Yeah.
Brandon Mingo. Brandon Mingo, that's Brooklyn Brewer.
Haven't seen the attorney yet this morning, Judge.
And Reagan, Mr. Khan.
Mr. Khan.
What's up? Please.
Okay, once again, Judge is getting all whispery. Let me see if I can push past this.
So currently he is under bond conditions that do not give him any access or allowance to access the internet. We are requesting that that be amended to allow him to access it for purposes that include his international student status. He is on a visa that since graduation has allowed him to work, and that visa is valid until February of 2027. With that, he has certain requirements that come from the Department of Homeland Security where he has to report statuses and changes of address or jobs or anything else like that, and he has to do that through an online portal.
Okay.
Additionally,
Okay, explain, but I'm sure there's a need for it. Tell me how we deal with the fact that he misused the computer and internet to commit these crimes
well, Judge,
and promote child abuse, right?
well, Judge, you know as well as I do that everyone is presumed innocent, and right now, under this presumption of innocence, we don't know that that is something that he actually did. Right now, he's just
No.
under a bond condition
Okay.
where he can't access the internet.
This is a probable cause, affidavit based upon probable cause, but what I try to do is freeze the circumstances, freeze them until we can dispose of the case.
I
And
think, Judge.
this, you're asking for him to get back into the internet where there's probable cause to believe he misused it.
Judge, I'm sure that you are all aware as I am that we live in a purely virtual society almost today. He has requirements where he has to report his status online, and it's a fully online process.
Computer is not a right, and computer is not a right, and it can be when we're talking about child pornography. We're going to just freeze this action. I'm sorry about this, about his issue. Though also we've got the victimization of children as alleged here. And I don't want to have a problem of revisiting this during the course of this case. But if that's the Brandon case, isn't it?
It would just say judge, and he has to give a status update by Wednesday of next week, the 24th.
I have historically, when people have misused the computers, I have historically prevented that as a bond condition. But I haven't heard this, what the state says.
Judge.
What do you say?
Judge, of course, we object. There are offices for immigration for purposes for him to go and check in personally. He doesn't have to do it by internet, but it's more convenient for him. So we would.
What about that?
The Lamar portal that his funnels through, the Lamar portal specifically is online. So he has to report to.
Is there anything else he can do here in this area without accessing it?
I have asked him if he can go in person and
Has he talked to immigration, INS here or US Customs? Why don't we do that?
The requirement that he is under is he has to give an update within 10 days of something changing of his status. So from this issue that has arisen, he has to report that update of no longer being employed by the 24th. And it's my understanding that that has to be done through an online portal. I understand historically that this access has been frozen for people, but here recently we have the ability to monitor people's access online. So if that is something that the court is willing to explore, then I think that's something that we can agree to.
Judge, I sent the link that probation uses for people who are on probation that not only registers their online status, but also their keystrokes, everything else, and it's in your file.
So how does that work?
They have to install it onto their computer. I don't know if it would be, you'd have to order it be monitored by somebody. I don't know who would monitor it on a bond because the bondsman won't. I don't think they'll take that responsibility. Plus, they have to pay for the individual has to pay for it every month.
What about that
program? But I don't know who's going to monitor it.
Well, something has to be monitored, or else what's the good of it? Right?
Yes, Judge, but
Well, I mean, give me a plan on that. Give me a plan on that. I like that. That's okay to work through the probation office.
If probation, I don't know, probation is not,
can y'all check on that?
I can probably give you it.
Well, see if.
And if that comes with some kind of monthly supervision fee or something as well.
That's not important. Yeah, that's
to use the probation office.
But it's the monitoring.
I understand.
I don't want him misusing it.
But I think if it's between not having any access and him being able to have access in work.
I'm not going to give him any access unless I can be assured that children are not going to be exploited.
Sure, I understand, Judge, but I think
figured out.
I think if that's the difference or the options, we would agree to the monitoring aspect.
I know,
of it
but but what monitoring is it? We don't. Nobody's told me. I just said monitoring in general. There has to be a plan.
Right.
So can you figure it out?
Yes, Judge.
I'll come back Monday morning.
All right.
He's got till Wednesday, right?
I'm willing to go with.
Yeah, you can come Monday morning.
Yeah, when we do that.
If that's safe.
Okay. Thank you, Judge. I'll work on that.
And then Brandon Mingo, Brooklyn Brewer. Yes, ma'am. What are we doing?
I was trying to speak to this before we approach it.
Yes. I've got a trial. I got a murder trial, murder of a child trial.
Yes, sir. I better approach this. Good morning.
Yeah.
I was gonna share with the state, but it's on here, Mr. Amigos, paycheck stubs.
What are you asking for? I don't know what you're asking for.
I would like to get some type of deferred.
Well, that's between y'all.
Yeah, that's what we were still talking about it, but I know that the prosecutor was on the case.
It's me.
It's him.
You talked to him last time. You talked to me first time.
Okay.
But
y'all talk and decide if something can be done and.
I think that's what you put in the file. The first on the table. You want the first probation with.
Okay. But I want to show you what
I believe you.
and even welding school.
Okay.
That is doing it.
When do you want to do that?
Do you want to do it today or you want to talk to him and do it later?
What's the time?
He decides.
There's just, okay.
He gets to decide up to 10 years.
Well, do you want to do it today or when?
Would you like to resolve?
Quicker you put, quicker you get placed on probation, the quicker it is. But some people like to postpone things, but I always thought the quicker it begins, the quicker it ends. Tell the jury we're going to need about 10 minutes, please. Thanks, Dennis.
If you're on her, Dr. Barnum, we're on there, and we'll see.
All right, let me see if I can bump us past this quiet part. Because it sounds like we're going to do one more hearing.
So that's why I was.
It needs to be turned. You can see where the.
That's how you look at that.
No, I guess we're not. They just moved over to trial stuff. Okie dokie, let's go here, back to Ohio, but this time Judge Collada.
We're present in case 23 CR 500, State of Ohio versus James Carson. We're here on a motion to terminate community control sanctions. Defendant previously waived the probable cause hearing. Scheduled for a final hearing at this time. Defendant is here in court with counsel, Mr. John Fatika. Mr. Fatika, what's the defendant's intention at this time?
Good morning, Your Honor. Mr. Carson would like to waive his final hearing, accept responsibility for his misconduct, and resolve violations today.
Mr. Carson, you've been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated, let me get this up here. Do you guys have a recommendation in the folder? I don't see one. Specifically, it's alleged you violated Rule 3, which requires you to report at such times and places as directed by your probation officer. And it's alleged you failed to appear on Tuesday, August 12th, Tuesday, August 19th, and thereafter. It's also alleged you violated Rule 4, which requires you to report to your probation officer the address that you are actually living. You're not to change that address without prior notification and approval of your probation officer. And it is alleged that you were negatively discharged from Project Hope on August 4th, and you did not advise your probation officer of any other address where you were residing, and your current whereabouts as of August 20th were unknown. It's also alleged that you violated Rule 1. Rule 1 requires you to obey all local, state, and federal laws, and it's alleged on August 2nd you were charged with no operator's license and operating a vehicle under a suspension. And then just recently you were convicted of that charge. Now, you have the right to have a final hearing regarding these allegations. That's a hearing where the state would be required to prove the actual merits of what they are alleging. You could have this final hearing but you could also waive the hearing and plead guilty to the violation, the violations, I should say. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to advise you the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. It was originally 2.5 years. I extended it another 6 months the last time we were here for a probation violation. So I could extend it up to another 2 years. I can impose more restrictive sanctions, including an order that you serve time in the county jail, or I could terminate your probation and send you to prison. If I did that, it could be anywhere from 6 to 30 months in prison. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violation?
I'll waive the hearing and plead guilty to the violation.
Very well. As the allegation, you violated Rule 3 by failing to report to your probation officer since August. What is your plea to that?
Guilty.
As the allegation, you violated Rule 4 by not providing an address where you're residing. What is your plea to that?
Guilty.
And as the allegation, you violated Rule 1 by having been convicted of a new offense while on probation. What is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Fatigue, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. The DUS that is the basis of one of the violations was resolved in Painesville Municipal Court. Mr. Carson served his 3 days on that. I received a telephone call from his cousin, Delia Mackey, who indicated that Mr. Carson could reside with her at 7720 Sagamore Avenue in Cleveland, 44103. Mr. Carson has credit for 355 days time served. We'd ask the
That was
court.
358.
I'm sorry. What did I say?
You said 55. It was 61.
No,
And then the 3 days comes off of that.
358, I'm sorry. We'd ask the court to consider all those factors in fashioning a resolution.
Mr. Carson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Your Honor, I would like to apologize for being in contempt of court, I would call it, not going to see my probation officer, and for me getting pulled over knowing I wasn't supposed to be behind the wheel. It doesn't matter what I was doing, I take full accountability for it. I was trying to make it to a good friend of mine's funeral that day. However, somebody was tired. She was also on Project Hope with me, and she asked me if I would take the wheel. She was sleepy from the night before, but I knew I shouldn't have did it. Like I said, I take full responsibility, Your Honor, accountability, I should say, and I never got a chance to. I think I might have seen the new probation officer. I only knew David Tompkins.
No, you had a chance. You didn't take the chance. You had plenty of chances to see your new probation officer.
Yes. And I kind of when I got the ticket was August 2nd.
Which is a week after you were here in court.
Yes.
Refresh my memory, when he was here in court for the first PV, I gave him like 30 days of TDR.
Yes,
So how was he out?
he did have a job lined up and he was living at Project Hope.
So he didn't do it hardly, he got out pretty quickly after the last hearing. Is there anything else you'd like to say, Mr. Carson?
No, Your Honor.
Take anything else on behalf of the defense?
Your Honor, I just wanted to have a clear record. I was under the impression that this case involved an F4 conviction. You mentioned a possible 30 months. I believe the cap would be 18.
Not for an OVI. Felony OVI, it's 6 to 30 months.
Oh, okay.
And he was advised of that at the plea as well.
Okay.
Felony for OVI, you can get up to 30 months in. Well, this court has considered the pre-sentence report and investigation. I've considered the facts and circumstances of the underlying offense, the nature of that offense. I have considered the defendant's performance on probation. And I've considered everything that's been said here today. All this is considered under the purposes and principles of felony sentencing set forth in 29:11. So the factors in 29:12, I'll incorporate all the findings I made throughout this case regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply with previously imposed sanctions ordered by this court. One of those conditions is that he did pick up a new offense. So not only does the recidivism more likely it actually occurred. In this case, the defendant's criminal history goes back over 30 years. He's got 1, 2, 3, 4, 5, 6. This was his 7th OVI offense. He got a big break with the plea in this case to begin with not having a specification on this case. He's violated his probation once before for failing to report, and literally, I didn't even do anything to him really last time, and then he immediately failed to report again. I think a week after we were in court. And then he was gone for 6 months. And while he was gone, he was driving, that was early on, but one of the violations also was for driving a car with an OVI suspension from this court. At this point, it's clear the defendant is no longer amenable to community control sanctions. Prison is consistent with the purposes and principles of sentencing. Therefore, as a sentence to this court, then count 1, defendant served a term in prison of 18 months. He has credit for 358 days he's already served. I need to advise you, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. Were there any payments made on the mandatory fine that were ordered in this case?
No.
Well, that's still out. I'm not reimposing that. It's already been imposed. That's still out there. Is there anything else for the record, Mr. Batika?
No, thank you, Your Honor. All rise.
Okie dokie, friends. TCF Live. It is Super Friday. Hope you're all having fun so far today. Been an interesting day in court. Feels different from what we normally see on Fridays. I don't know if that's good or bad. It just feels different. So if you were a channel member on the pre-show this morning, then you know that we had a little special something to start off the morning. And it was based on what happened in Sidebar last night. So if you haven't seen Sidebar from last night, go watch that. But basically, we invented 2 new superheroes, Meth Boy and Rock Girl, and there's some lore behind it. But we had a poster, basically a comic book cover, if you will, for Meth Boy and Rock Girl, and somebody in the chat at some point this morning said that should be merch. So I've been working behind the scenes, and there it is, my friends. I will drop a link as soon as I'm done flapping my gums into the chat. Your official Meth Boy and Rock Girl poster. If you are a channel member and you want that, be sure to use your discount code, because it basically just brings it down to cost. So it gives you like the best deal possible on it. And I guarantee you that the adventures of Meth Boy and Rock Girl will become a regular thing in the pre-show. So be sure to check that out. Pick that up if you want. It was Great Granny. All right, well, there you go, Great Granny. I've used their posters before for other projects. They're really high quality. It's worth picking up. And yeah, I'll drop a link here in just a moment. In the meantime, let's go back to Judge Elmore.
appearances, beginning with the prosecutor's office.
Good morning, Your Honor. Dan Olson, I'm here on behalf of Ms. Noelle Muggenberg, Special Prosecutor from Grand Traverse County.
All right, thank you.
Good morning, Jennifer Carbolisi on behalf of Mr. Thomas, who appears in court, Your Honor.
All right, thank you again. Mr. Olson is joining us today via Zoom, which the court has allowed. I see that we have another person, and I assume that's just a staff. Sorry, I used the word just. I don't want to use the word just. This is an awesome staff member apparently from the prosecutor's office. Is that right, Mr. Olson?
That is correct, Your Honor.
Good, thank you. I apologize for the word just. All right, folks, we're here today for a couple different things. I'm going to cover what I thought we might be doing, but what I think we are now doing. There originally was a motion filed by the defense to adjourn the trial date. That was dated February 12th. At least it was dated February 12th. Somehow I suspect that might be a mistake because the proof of service says March 12th.
It must be March 12th, Your Honor, yes.
Either way, then we received that on March 17th. However, I've also received dated March 16th, a signed pre-trial agreement and advice of rights. Thus, I assume we're here today for a plea. And Ms. Ferravento is on there. Let's move her away. All right, thank you. Put her into the matrix.
Your Honor, we may have a few victims on Zoom as well.
Okay, let's just get rid of Ms. Ferravento. Can we do that?
She needs to be invited.
I want you to tell me the names of the people that are also there.
We have Ron Ensign and Ivana Austhoff.
Are those people involved in the case, Ms. Weiss?
I believe that Mr. Ensing is the victim's father. I don't know if it's the
Okay.
actual victim that's here, and I do not know the name of the other person.
Would you like me to bring Mr. Ensign in?
Yeah, bring in that individual. And out of respect, we now have an individual. Well, there we go. This says Ron, but you don't look like a Ron. Ma'am, what is your name?
My name is Maria Ensign. I'm
All right,
Priscilla's mother.
All right, thank you. Now, there is another person who is apparently listed to join the Zoom room. Ma'am, Ms. Ensign, I'm gonna ask you if you know the person. Madam Clerk, what's the name?
Ivana, last name is Austhoff.
Does that sound like anybody you know, Ms. Ensign?
Yes, Ivana Osthoff. She's my other
And who
daughter.
is? Okay,
We also have a Jillian now as well.
holy cow. Do we know who this, Jillian? What's Jillian's last name?
It just says Jillian's iPhone.
Do we know any Jillians involved in the case?
No, sir.
I don't know. All right, they can just watch on Zoom. What do you call it? YouTube. Thank you. All right, so we got everybody here that we need. Let's go ahead and tell me I'm going to cover what I think we're doing. Are we doing the plea?
Yes, sir.
All right. So as I understand it, pursuant to the pretrial agreement form that was presented to the court earlier this week, the defendant, who is currently charged with a count of criminal sexual conduct in the first degree, count one, and then another count of the same offense. Instead of that, those two counts are going to be dismissed if the defendant enters a guilty plea to, and the court accepts those pleas to, added counts 3 and 4. Those added counts would both be for an allegation or charges of criminal sexual conduct in the second degree. Is that correct, Mr. Olson?
That is correct, Your Honor.
Is that correct, Ms. Weiss?
It is, sir.
Is it Weiss or do you go by Weiss?
I'll go by Weiss.
Whichever one you want, all right? All right, thank you. And there are no other terms to the agreement. Am I correct, Mr. Olson?
That is correct, Your Honor.
Am I correct, Ms. Weiss?
That is correct.
All right, so now I'm going to turn to you, Mr. Thomas. Is that how you wish to, and you may remain seated here. Is that how you wish to resolve it?
Yes, Your Honor.
All right. Please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide will be the truth, the whole truth, and nothing but the truth, sir?
Yes.
Thank you. You may lower your hand. All right, Mr. Thomas, we're going to go over all this, and if you have any questions along the way, all you've got to do is let me know. And if you need to speak with your attorney, just lean over. I'll stop talking and you can talk to her, okay? You are currently charged on a piece of paper that's called a felony information, and on it you are charged with 2 counts. Each one of those are a count of criminal sexual conduct in the 1st degree. Each one of those are a felony punishable by up to life in prison or any term of years, mandatory lifetime electronic monitoring, mandatory AIDS and STD testing. DNA would have been taken upon arrest, and the court could impose consecutive sentencing. That means that if you were sentenced for, just using some random numbers, 5 years for count 1 and 5 years for count 2, consecutive means you'd have to serve 1 and then another one back to back, i.e. a total of 10. You understand?
Yes.
All right. Also, there would be sex offender registration under Tier 3 of the Michigan Sex Offender Registration Act. Tier 3 is the most strenuous. It is registration that you would do. It's fine. This is the one question I always forget. Quarterly. I know it's lifetime, but quarterly is what I wanted to make sure we got. Now, those 2 counts will be dismissed if you enter 2 guilty pleas to added counts 3 and 4. Each one of those would be a count of criminal sexual conduct in the 2nd degree. Each one of those are felonies punishable by up to 15 years. And there would be sex offender registration. And for a criminal sexual conduct in the 2nd degree, I understand here that at least right now, the alleged victim was an adult.
She was an adult. Yes, sir.
All right. That would be for 25 years. It would be biannually, and it would be a tier 2. You understand?
Yes, sir.
All right. Now, those would run concurrent to one another, not consecutive. So, for instance, if I gave you 2, and I have no idea what the sentence would be, I'm just using random numbers, so don't read into it. If I gave you 2 years for one and 2 years for the second, you'd only serve 2 years total. Does that make sense?
Yes, sir.
Great. You have any questions about that? Now, the court could, depending on how these guidelines work, could give even a jail sentence. When somebody gets a jail sentence versus a prison sentence, they get good conduct time, 5 days for every 30 days they spend in jail. You don't get that in prison. If you also get a jail sentence, the court can also issue a period of probation. That could be up to 3 years. And there could be terms and conditions of those probations, such as no, I don't know, but examples are generally no consumption of drugs, alcohol, illegal controlled substances. And one of the bigger ones is don't violate the law. If you were to violate the law, by the way, if there's an allegation that you violate it, you don't get a full trial, at least on the probation allegation. And then you could be violated on your probation and get additional time or even get a prison sentence, okay? So, but if you also get probation, you also have the right after halftime to request release from your probation if you've been successful. So again, if your probation were for 36 months and you made it 18 months, then you could petition the court to terminate probation because you've been successful. There also would be some fines and costs that could be assessed as well. You understand?
Yes, sir.
All right. You have any questions about what you're charged with?
No.
You have any question about the 2 charges to which you're pleading?
No.
And do you have any questions about potential punishment, sex offender registration, at least as far as I've gone over thus far?
No, sir.
All right, great. Now, I have here a couple documents. I'm just going to go over those with you. The first one I'm going to hold up is this plea agreement. It's got 2 pages, and the signatures appear on page 2. And it looks like I see the signatures of the prosecutor's office and your defense counsel, but also you as well. Is that your signature there?
Yes, Your Honor.
All right, now, did you read through both pages before you signed it?
Yes, sir.
And before you signed it, did you talk to Ms. Weiss about it?
Yes, sir.
And did she explain the terms and conditions and potential punishments and all those things with you? Has she also talked to you about what, probably going over the police report and all the evidence and information in it? Right. And here's what's an important question. One of the big questions here is, was she able and available to answer your questions?
Yes, she was.
I anticipate she would be, but sometimes you get attorneys who aren't that responsive. But she's been responsive to you so far and answered your questions, and you guys have talked about potential defenses and things like that. All right, now, are you satisfied with her representation up to the date?
Yes, I am.
All right. And so far, we haven't gone over all your rights yet, but you believe, at least right now, that what we've talked about is in your best interests?
Yes, sir.
All right. Now we're going to move to the second document, and this one is your advice of rights form. And here it has your signature at the bottom, at least it looks like. Is that your signature?
It is, yeah.
Did you read through all these rights before you signed it?
Yes, sir.
And did you understand the words that you read?
I did, yes.
And did you talk about them at all with Ms. Weiss?
Yes, sir.
Do you have any questions about them? Here's the important question. This covers all your rights for, like, going to a trial. You understand that if you plead guilty today, and I accept that plea, you will be forever waiving these rights as they apply to this particular case?
Yes, sir.
Okay. Now, you'll also be given up the right to claim that the plea was a result of some promise, threat, inducement, that I haven't heard about today, and you'll be given up the right to come back. So I want to make sure, have there been any other promises, threats, or inducements from anyone about getting you to enter this plea?
No, Your Honor.
Okay, so therefore, you enter the plea of your own free choice?
Yes, sir.
Now, there's another question here. I think you still have it. I don't know if you necessarily need it, but I know Ms. Weiss has got it available. On page 1 of that pre-trial agreement, you're going to look down toward the bottom and you're going to see the paragraph 5. You see that?
Yes, sir.
Now, what that says, it says the estimated sentencing guideline range is as follows. So in Michigan, for felonies, and these two would be felonies, there are guidelines that the legislature gives courts to use to help courts establish a reasonable and proportionate sentence. They are, however, not mandatory. I want you to understand that. So what these guidelines are, and you'll see even here, right here in paragraph 5, it says the word estimate. That's the attorney's best estimate. You understand?
Yes, sir.
And sometimes they're wrong. Sometimes a lot of times they're spot on. But the point is it's an estimate. They don't know yet if that's the exact scoring, because, for instance, they might all be looking at prior, and I know I've been told there's no prior criminal history, but sometimes, and I don't know you, so don't take any insult. Sometimes there's something that pops up and the person goes, oh yeah, I forgot about that one time I was in California. So anyway, out there, everything can be a crime. I think watering your lawn on a Wednesday. But anyways, the point there is that's just an estimate. You understand?
Yes, sir.
Okay. Now, has anyone made any promises to you or led you to believe exactly what I would do for sentence? All right, because I don't know. No one's talked to me about potential sentencing. And that's what I want to make sure you understand. There's no promise as to exactly what the sentence is. It's very appropriate for your attorney to let you know what she thinks, and the prosecutors let you know what he thinks the guidelines would be for that minimum end. So do you have any questions or concerns?
No, Your Honor.
All right. So again, do you still wish to enter the pleas as we discussed?
Yes, I do.
Okay. Now, there's one thing also, when we do a plea here, I'm going to have to ask you, and you're going to have to tell me what it is that you did that makes you guilty of the offenses, at least with added counts 3 and 4. Do you understand?
Yes, sir.
All right. So, as to added counts 3 and 4, which both allege charges of criminal sexual conduct in the 2nd degree, how do you plead?
Guilty.
All right. Thank you. So now what I want to do is we're going to talk here a little about what happened. On July 27th of last summer in 2025, you apparently were in Cadillac or part of Cherry Grove Township. Cadillac covers 2 townships, Clam Lake and Cherry Grove, here in Wexford County. Where were you?
I was at
You can give
301 East Lake Mitchell Drive. It was a lake house
Yep.
over on Lake Mitchell.
Yep. Color was it?
I can't really recall the exact color.
I'm born and raised here. I know every house on the lake. All right, it's okay. So you were up here at a VRBO or an Airbnb or somebody else's house?
No, it was someone else's house.
Okay, so you were visiting with some other friends or student, I don't know, whatever friends, right?
Yes, sir.
And how many days were you at that residence?
I arrived Friday and then I left Sunday morning, so
Okay.
2 nights.
All right, and so tell me what happened that day or night?
May I inquire? Is it okay with Your Honor?
Let me see what I could use. This,
Sure.
I gotta earn my paycheck
Sure.
somehow. So, but Ms. Weiss, I'm gonna let her come back in and help me out here a little bit. You were at that house with a handful of other people, correct?
Yes, sir.
And what day did this event occur?
It occurred the night of the 26th, going into the morning of the 27th, so Saturday to Sunday.
All right, got it. And were you all consuming beverages like alcohol, things like that?
Yes, sir.
And were you all about the same age?
I believe so, yeah, within a 2 to 3 year range.
All right, good. So you're up here and it looks like you're from Zeeland.
Yes, sir.
I used to, I did my student teaching at Zeeland High School. Has nothing to do with this, but anyways. So what happened? You were consuming alcohol and somehow late at night, did you go to bed at some time or go to sleep?
Yes, I went to bed.
All right, did you wake up?
Yes, I
Okay.
believe so.
Oh, well, you believe so. Well, then tell me what happened. What did you do? And it looks like this involves a person whose initials are PE. Why don't you go, and I'm just going to use those initials so we know who we're talking about, but and you know who I'm talking about with PE?
Yes, sir.
We just want to be respectful of that individual. So what happened involved between you and PE?
I woke up in the room that PE was sleeping in, and I had put my fingers in her vagina and my mouth.
In your mouth?
Yeah.
All right, so you had put your mouth onto the openings of her vaginal label area, is that correct?
Yes, sir.
And was she awake at that time?
No.
All right, and did you know she wasn't awake?
Must have.
Well, let's be very careful. This is why I knew what we might be running up against. That's why I said I was going to ask the question. So, not to must have, because I know there was a potential defense.
Yes.
And there was talking about sleep apnea and things like that, which, by the way, I know a little bit about those issues. I've been a defense attorney. So you went in, did you go from one room into her room?
Yes.
And was she in a bed?
Yes.
And was she sleeping?
Yes.
And when she was sleeping, you, without her consent, and placed your fingers into or on or around her vaginal area or into the vagina, is that right?
Yeah.
And then you put your mouth and tongue areas on the same, mouth on the same area?
Yes.
All right, and again, at the time each of those two events occurred, you knew that she was sleeping.
Yes.
All right, so that covers the helplessness for CSC 2750.52 C?
Yes, sir. Subsection G.
Yep. All right, so now we have one more question. This one's going to be the tough one. All right. So again, she didn't give you consent to do this, correct? And you didn't have a relationship where you might think this was appropriate, correct? All right, so now the difficult question today that we might have is, how did this impact her? Do you know? Were you there when she woke up?
I was there when she woke up, yes.
All right, so the key question here that I'm looking for, and Ms. Weiss, maybe this is where I'll let you try to help me out, and that is, I assume that we're probably going under the mental anguish, because there has to be a physical injury, which could be a physical bodily injury. It can also be mental health, and specifically underneath the statute, they use the language mental anguish. Go ahead, Ms. Weiss.
Thank you so much, Your Honor. I appreciate it.
Mhm.
Sometime during the course of our discussions, you met in my office multiple times, correct, Mr. Thomas? And we had talked to the prosecutor who's not present today, Ms. Mildenberg, correct?
Yes.
And I informed you that she had met with the victim with the initials PE on this case, correct?
Yes.
And that PE had indicated to the prosecutor that she was really suffering based on what had happened to her at that lake house in Wexford County, correct?
Yes.
And because of what you did to her.
Yes.
And that she was probably going to or was in counseling already because of it, correct?
Yes.
And that she was, because of her suffering, that was part of the plea agreement as to why you would be pleading to this charge, correct?
Yes.
And it was part of the reason why Ms. Mogenberg enhanced the charges from a 3rd degree to a 1st degree at the beginning of this case, correct?
Yes.
Thank
All
you,
right.
Your Honor.
Thank you. All right, Mr. Olson, do you believe Mr. Thomas has provided sufficient facts to establish the elements for added counts 3 and 4?
Yes, Your Honor.
Are you aware, Mr. Olson, of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court, along with the assistance of Ms. Weiss and the information provided by Mr. Thomas, comply with Mission Code 6.302?
Yes, Your Honor.
Ms. Weiss, do you agree with all 3?
I do, thank you, Your Honor.
All right, thank you. Now, there's one small issue that I want to go over here. And I'm going to be very delicate here with it, and we're going to work through it openly. I know that there was this previous defense that you all were looking into. Mr. Thomas, you're aware of that, correct?
Yes, sir.
Understand that you are foregoing that defense strategy, correct?
Yes.
And now, what I'm also concerned here with is not only that you knew that, but what I would be concerned with is somewhere down the road, an appellate attorney would say, well, Ms. Weiss was ineffective, and I'm not saying that at all, Ms. Weiss. Did you talk to her about not going down that direction?
Yes.
I know there was some report that you've met with some sleep specialist, but you understand that you're not going to go down that road. Is that correct?
Yes.
Yeah, and you're satisfied with this decision and your advice that you received from Ms. Weiss about not going down that road any further?
Yes.
Okay, good. All right. Yes,
No,
ma'am?
I really appreciate you going through that. I wanted to just ask Mr. Thomas a few more questions.
Yeah, go right ahead. Thank you.
Part of our consideration for moving forward with the plea, obviously, were the pros that the judge outlined very readily at the beginning of your plea today, given the sex offender registration, as well as the consecutive sentencing and the guideline differences between a first and a second, and mandatory prison for a first versus non for a your plea agreement. And those are your choices, correct?
Yes.
And you understand that we can still use any of the information that we have been discussing as a defense for mitigation purposes at your sentencing.
Yes.
And that's the way you wanted to proceed today.
Yes.
And that was your choice?
Yes.
Okay.
And the one thing, and I don't think Ms. Weiss was intending this, but I just want, because we may live on words here. When you come back for sentencing, you might provide information about that. For instance, let's say you had a mental health issue or physical issue, whatever. You'd want to express that to the court. The key issue is when you come back for sentencing, you can't go back and you can't say anything that's going to try to say, well, Judge, I had a great defense. This is where I was going to go. Because if you do that, well, we'll have a big discussion that day. All right, so I just want to make sure you understand that. And I'm sure Ms. Weiss, she's shaking her head yes, doing a lot of head nodding.
Yes, sir.
All right, thank you. Anything further, Ms. Weiss, before I accept the plea?
No, Your Honor.
Mr. Thomas, any questions at all about what we have done today?
No, sir.
Do you have any questions about the pretrial agreement that you've entered? And do you have any questions about the pleas that you have made?
No, sir.
Thank you. All right, the court finds that defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfied the required elements of proof for added counts 3 and 4. Therefore, the court finds the defendant guilty of added counts 3 and 4 for criminal sexual conduct in the 2nd degree. And the court finds that the testimony does involve, actually could involve allegations or facts that might support another offense, whether it's CSE 1st or 3rd, but the court is allowed to accept it as a lesser included offense. So that's something we're trying to cover there. Therefore, the defendant is found guilty of added counts 3 and 4. Counts 1 and 2 will be dismissed at the time of sentencing. All right, Mr. Thomas, when you leave this court, you're going to go downstairs to the Department of Corrections, or also known as the Probation and Parole Office. If you take that elevator all the way downstairs, step out to a sharp button hook to the right, there won't be anybody there to throw you a football, but down that hallway, there's a door. You go through that door. On the end of the hallway on the left-hand side is the Department of Corrections. I assume, did you have to do anything through community corrections?
I did, yes.
So if you were to stand in front of community corrections, do an about face and take 3 steps forward, your face would hit their window. Go down there, they're going to give you a packet. You're going to complete that packet and turn it in. They will also set up an interview with you, and you have the right to have your counsel present during that interview. They will also prepare a report that will go to your attorney, and your attorney is going to have to sit down and go over it with you prior to coming back to court. Each side has the right to come to this court, request corrections, make objections. Maybe it's in the scoring, maybe it's the language or information inside, or just request corrections that are really simple. The thing is that this report is prepared by the Michigan Department of Corrections anytime someone is convicted of a felony in a state court here in Michigan. This report will describe the offense, the pretrial agreement, any statements, information you make or provide, as well as information about from the victim if she so chooses. She also has the right to be present in the courtroom at the sentencing and make a statement if she chooses to do so. This report will also include a scoring of the guidelines. I remind you that the guidelines are not mandatory. I'm very big on making sure that's accentuated because courts have discretion. But again, they are a tool that I will use to help establish what I think is a reasonable proportionate sentence. The things that I look at, I'm going to look at the description of the events. I'm going to look at what the PE said. If you don't have any priors, it's great because I put a lot of weight on prior probation violations and parole activity and bond issues, things like that. But anyways, that information will come to the court and the court will use it for sentencing. Now, do you have any, Mr. Olson, anything further today from the prosecutor's office?
No, Your Honor. Well, actually, Your Honor, I would believe maybe perhaps an alcohol or substance use assessment may be appropriate in this case.
Did do one privately and has done a trust group and has been on bond doing colors, if that helps at all with the court's decision on that. No violation.
I'll be fine with that if you provide
Sure,
some
yes.
kind of assessment that tells me what's going on there.
Absolutely.
All right, thank you. Anything else, Mr. Olson?
No, thank you, Your Honor.
All right, thank you. And Ms. Weiss, anything else?
Just given your statements today, Your Honor, I'm not sure if it's going to be helpful at all to the court in determining a sentence for Mr. Thomas. He does have no criminal history. We did have that sleep study set up. It's not our defense. I wondered.
Just be careful how you present it to
I
me.
completely understand that. Would you like for us, it's not scheduled until May 31st.
You just be careful how you present it to me. I'm not going to tell you what to do or don't do. Just don't make it look like it's a defense, because if it's a defense, I'm going to have issues.
Understand.
Right.
I guess what I was trying to ask was, would you mind the sentencing be after we receive that study? I know that's
I
a
don't-
long time. It would be like
well-
June probably. That's a long time. So I just wanted to make sure the court was aware of that. We could try to get it in earlier. He does have a.
Let's do this.
Okay.
One, I know I've got a vacation in the middle. I've got 2. So I have no idea how far. Typically, sentencings are 4 to 5 weeks out. So I don't really know what my staff will do. Let's see what Nicole puts on a piece of paper.
Okay.
And then if there's any requests and you want to adjourn it, you can.
Thank you.
You can request that. You can even do a stipulation if the prosecutor's office agrees and so forth.
Thank you, sir.
All right.
Thank you.
I'm sorry, Mr. Olson, I forgot to ask you one question. Any objection to the continuation of bond?
No, Your Honor. Thank you.
Thank you. Mr. Thomas, your bond conditions remain in effect. Now, one of the things you definitely do not want to do, don't take this as any offense because I don't know you. You don't want to violate your conditions of bond and you don't want to commit any criminal conduct, right? Because I guarantee you that will be weighed heavily. But we're not going to talk negatively. We're going to talk positively. All right. Thank you very much. Ms. Ensign, thank you very much for being here today. We are adjourned.
Thank you.
Thank you.
Thank you.
So it's rare that, at least here on TCF, that I've seen a judge issue a warning when it comes to how you're going to defend your client. And his flat says, don't use the sleep study defense. I don't know why men, and quite honestly, there's women that do it too, how they get into this crime. If that's what you're seeking, it's just not that hard to find. It just isn't. I don't know. But, you know, we could beat that horse to a bloody pulp. There's no need. Let's move on, and let's move on to the thing you've all been waiting for, because they were not live last Friday the 13th when they should have been. That was sad. But let's go to our favorite place, our Friday guilty pleasure, the place where the carpet is the shining crimson, copyright. The chair of eternal doom, the accent lighting upon the walls, the screams of babies in the background, the souls of the dead occupying the room clearly, the lighting hanging over the tables that screams Soviet era. For some reason, Great Granny always wants to use those for swinging. I'm not sure what's up with that. But ladies and gentlemen, I give you Dungeon Court.
Do your screen, go to the probation when it's going to show. So we'll call, do your screen, go to the probation, do that, and we'll call you back after we get the results. Kaylee Bennett. Kaylee Bennett. Case numbers are 20, 2680, you are here 20, 2681, 21, 2280, 22, 1604, 22, 170.
Well, he calls those out. I did forget. Lindsay, thank you for placing an order over at courtroomfiles.com. I see you got the poster, and you also got yourself an Under Armour hat. Very cool. Thank you so much.
All right, let's get this community service done. Give me a date when you're going to be out.
Can I do it Friday?
A week from today?
Yeah, or I can try to do it tomorrow.
Tomorrow's better.
Okay.
Be here tomorrow at 7:30, so Mr. Cooper will be looking for you. I'll set April 24th as your next hearing. That's a Friday. April
Okay.
24th, 9 o'clock.
Thank you.
You're welcome. Tiffany Brooks, 25177. A report from RRS. Well, still positive for THC.
Yeah, my levels are decreasing though.
Okay. Is that correct?
Yes, sir.
And you're working off your fines?
I thought I finished all that.
I'm showing still $130.
Oh, I can pay it today.
Okay. See the clerk then to make a payment and continue with your counseling.
Sir.
And I'll set your next hearing. This is a newer case I'm going to go into May for you.
Your Honor, if I may, RRS advised me she has another case here next week also.
Okay, well, you need to be here for that then. But for this one, I'll set your next hearing for May 1st. We'll try to get them together if that's possible. So see the clerk to make your payment.
Okay. Thank you.
Tanner Collins, 2612. Bethesda.
He's doing well, Your Honor. He's compliant with all program recommendations.
Okay. So you either have a job or looking for a job, what's that?
He's not there yet.
Okay, he's looking for one.
Yeah.
And he's inpatient.
Yes, Your Honor.
Okay. All right, so we can wait on the other stuff, bonds and community service. At some point, though, if you can do some community service come in here, that would be good.
We'll get him on the schedule this month.
Okay. Let's go April 27th, that's a Monday. April 27th will be his next hearing, 9 o'clock.
Thank you, Your Honor.
Thank you. Cynthia Gann, 25,547. And we're looking for report, going from TPC, which we've got in hand. Says you're compliant. Looking for a job and housing. Is that right? Okay.
Your Honor, if I may, Ms. Gannon was ordered on February 20th to have some community service done before the next hearing. She is not there.
Okay, tell me about that. Can you get out here or?
No, I was gonna do it in Ironton. I'm complete on like the 30th, I was gonna start it then.
Okay, so can you all get her to community service in Ironton?
Yes, we probably could.
Okay, well, let's get that done. She's got 5 days she needs to. If she can do it at the municipal court in Ironton, right downtown.
All right, thank you.
Okay. April 24th will be her next hearing, 9 o'clock. Continue with your counseling.
All right. Thank you.
You're welcome. Joshua LaPrade, 2358. Community service, fine. Do you have anything you can pay on your fine today?
Yeah, I gotta go pick it up and come back and pay on it.
Okay, so
I'm gonna pay it all off.
You're gonna pay the whole thing?
Yep.
$275.
Yes, sir.
And you got community service to do too.
Yes, sir.
Okay. I'm gonna set this with Mr. Major for a follow-up review rather than with me, because it's a driving under suspension. So let's set it for Wednesday, Your Honor. Any Wednesday, April 29th. What time?
9 a.m.
April 29th, 9 a.m. And you'll go to probation. So see the clerk to make your payment, and if you get your community service done before then, you don't have to come back.
All right, thank you, sir.
You're welcome.
Michael McKenzie, Adam Reimer, Ashley Sharrow, Jimmy Sparks, Savon Stallworth, Jason Packett, Erica Williams, Stephen Wolf.
Michael McKenzie, 25,699. Michael McKenzie. McKenzie's not here, and he has done, he's paid his fine, but he hasn't done any community service, so it'll be a bench warrant. He was supposed to be a cardinal also for treatment. They're not here to give me a report, and he's not here either, so he'll get a warrant for failure to appear. Adam Reimer, 22,327. Adam Reimer. It's OBI. He hasn't appeared. He's got community service and time still left to pay. So it'll be a bench warrant for failure to appear. Ashley Sharrow, 26,161. Just has fines to pay, hasn't appeared, so it'll be a bench warrant. Jimmy Sparks, 2635, is in custody. Seen I've got a report from hometown. Okay, so there was an incident where the allegation is that you shoplifted at Speedway while you were at the facility and out on some sort of project or something.
Yeah, they stopped at Speedway and he went in and shoplifted. The associate didn't catch him, but he was caught by a staff member when he came out.
Okay. And
But
then
we're still.
Speedway chose not to file charges, or?
Yeah, that was my understanding that they did.
Okay. All right, so are you willing to keep him in treatment, or?
We're still willing to work with him.
I have your letter, you wrote me a letter apologizing for this, and what do you got to say? And anything in addition to the letter?
Just a mistake on my part. I was about to have them on Speedway, and it was the wrong size. I took mine out, but I get them switched it out for the right size.
Well, did you talk to the clerk about it, or?
There was no talking to Speedway. I come out, and the staff member asked me about it. I just was like, yeah, that's exactly what happened.
Do you know anything about that? I mean,
I'll have my other.
Your Honor, that's what he told me. We did make him take it back in. This is the second time doing that. This when he was here, he got in trouble, put him in custody last time over the same thing.
okay. Well, I mean, it's very disappointing. I mean, you have done pretty well in getting clean, but you gotta change your old behaviors too. I call it the criminal mindset. You know, people like, you gotta change your criminal mindset. You can't steal, lie, cheat as a regular course of business. You know, that's wrong. And even if you're clean, it's still wrong. So what I'm gonna do, I'm gonna give you a weekend in jail. So you need some consequences of this. Do you still want him after the weekend?
Yeah, we can pick him up Monday.
Okay. Spend the weekend in jail, be discharged to hometown, do an entry to that effect, discharged back to hometown for treatment Monday, which will be the 23rd. And then I'll set your next review, and I'll see you sooner because of this. So let's make it April 10th. I'll see you back on April the 10th for a review, to see how things are going. We'll just remain in the custody for the weekend.
Great, thank you, Your Honor.
You're welcome. Sevion Stallworth. Okay. Community service done, you set to pay your fines. Do you have a payment you can make on your fines? Your mic's muted.
You have this unmuted, sir. I'm unable to pay today.
Okay. You can do, if you want to work additional community service, I'll let you do additional community service, and it'll go toward your fine. You get $50 a day for every 6 hours that you work. You want to do that?
Yeah.
Okay, you did 18 hours this last time frame. Just keep working, and it'll go toward your fine now. I'll set your next hearing for April 27th at 9 a.m.
Did you say that again?
April 27th, 9 a.m. The last, I think that's a Monday. Yeah, April 27th is the last Monday in April. Is your next hearing, 9 o'clock. You can appear by teleconference. as long as you're making progress.
No, you said something about 18 hours.
You did 18 hours this last time frame, so just keep working community service, it'll get toward your fine now.
Okay. And could you remind me of what my total is?
It's over $400 and some dollars.
400.
What was his file?
490.
490 is your total.
Okay.
So 10 days of community service will get it done. Okay, any other questions, sir?
No.
Okay, April 27th, 9 o'clock is your next hearing.
Okay.
Jason Tackett's here. Case numbers are 15, 29, 96, 17, 42. He's got a certificate of completion. Orange County recovery, so that's good. What about your fines? Are you paying anything on your fines?
Yeah, 50.
Okay. See the clerk to make your payment. And do you prefer Fridays? Doesn't matter for what day?
No, no.
April 27th, that's a Monday. April 27th, 9 o'clock, your next hearing.
All right, thank you, Your Honor.
You're welcome. Erica Williams. Erica Williams is not here, 2695. $25,635. She was supposed to be at TPC. Is there was somebody here from TPC? Can you find out if what happened with Erica Williams? Initially, she was ordered to go inpatient, so I don't know if she left treatment or what happened. I don't know. Erica Williams, middle initial B, date of birth August 7th. Okay, so we'll recall that, try to figure out where she is. Stephen Wolf, here's Stephen.
Yes, sir.
16,326, you just have to pay off a fine. And you're working community service to do that, it looks like. Is that right?
Yes, sir.
Okay. All right, you've done, you did a day toward your community service. It looks like 4 days will take care of what you got left. I'll set you for April 29th at 9 a.m. That's a Wednesday, and it'll be with Mr. Major in the probation office. So you won't be coming in on court day, you'll come in midweek. April 29th, if you get it finished before then, you don't have to come in.
Yes, sir.
Okay.
Thank
Very
you.
good.
State of Ohio recalls Charles Archer.
Your Honor, on my OVP gave them.
Okay. Oh, your screen's good. That's good. And is that what's in the file here?
Yes.
Okay. Okay. This is more detailed report. Okay, this is good. Good job. Keep it up. And stay with your treatment, and I'll see you. Where are you working now?
Sonic on Route 60.
Mondays or Fridays? What does it matter for your work schedule?
It doesn't matter, I work nights.
Okay. Let's put you on the 27th, and that's a Monday. April 27th will be your next hearing at 9 o'clock. Okay, good job.
Thank you, Your
Honor. You're welcome. Okay, that finishes up the reviews. We're going to call for arraignments next. If you think you had a review, go check in with the clerk and get your name on the docket. If you missed a hearing before, you're not going to be on the docket today. So when your name's called, come up to the table to your right, stand there. I'm going to go over the charges with you. You don't have to agree with the charges, but you need to understand them. and you have a right to have a lawyer. You don't have to say anything. You have a right to remain silent. But if you do make statements, with everything you say is on the record. So if you admit something about your case, that can be used against you later. You have a right to have an attorney appointed if you can't afford one, to have bail, and to make the state law approve the charge beyond a reasonable doubt. You give up those rights I just explained. If you enter a guilty or no contest plea, you shouldn't enter those pleas if you're not sure that's what you want to do. If you're unsure of what to do, or you want a lawyer or a trial, definitely enter a not guilty plea. Call the first case.
State of Ohio versus Genevieve Houlihan, case number TRC 26462, A and B.
And ma'am, are you Genevieve Houlihan?
Yes.
Ms. Houlihan, it's alleged by the state that on March the 16th at 1:32 a.m. in Union Township, you were driving a vehicle while you were under the influence of alcohol, that you took a breath test and tested 16 on a breath test. This is alleged to be your first conviction if you got convicted. On a first offense under Ohio law, the maximum you face is 6 months in jail, $1,075 fine, 3-year license suspension. There is a minimum penalty for this offense if you're found guilty. The minimum is 3 days in treatment, $375 fine, and a 6-month license suspension. The test score of 16 is above what's called the per se level. Under Ohio law, there's a per se level, and what that means is if you test 8 or higher on a breath test, and, this is important, and the and part, the state has to show compliance with the rules for giving the test. There's a presumption that you're impaired if you test 8 or higher. They're saying you tested 16. The other charge against you is driving outside your lane. That's a minor misdemeanor. The maximum penalty for that is $150 fine. Do you understand these 2 charges?
Yes.
Do you understand the rights I explained?
Yes.
How do you wish to plead to these charges?
I would like to request a lawyer if possible.
Okay, so we're going to enter a not guilty plea for you. Do you have a job?
Yes, I have 2.
What do you do?
Child Protective Services, and I bartend.
Okay, I have to determine your gross annual income. Do you know what that is?
Yes, I have my W-2s here, about 60,000.
Okay, well, you're not going to be eligible for court-appointed lawyer.
Okay.
You make too much money, so you'll have to hire a lawyer. How much time do you need to do that?
Possibly a week or 2.
Okay, well, I'm probably going to give you more time for that.
Okay.
So let's look at the court schedule and see. So it's going to be in April. How about the 13th? So that would be 2 weeks. I could go further if you'd like to need more time.
2 weeks should be good.
Okay, so I'll set you next hearing will be a pretrial on April the 13th, so be back here then at 10 a.m. unless your lawyer tells you they've made arrangements for a different date, then you come the date they tell you. I'm going to let you sign the signature bond, and what that means is I'm letting you sign a piece of paper that's a promise that you'll come to court, and it says if I don't show up, I'll have to pay $1,000 as a penalty for not showing up. And you get a warrant for not showing up, so that's the worst part. So just come to court, you won't have to post any money. I'm entering a not guilty plea for you, putting down to hire a lawyer. April 13th, 10 o'clock is your next hearing. Any questions?
Yes. One of my jobs requires that I drive to visit families and children in schools. Is there any way to do a work permit?
Well, there is. If there's a hard suspension, you really need to, since you took the test and tested over the per se level, an automatic license suspension went into effect. So your lawyer would have to file something with the court to get you driving privileges. So that's something you need to address.
Okay.
Any other questions?
No.
Okay. April 13th, 10 o'clock, the next hearing.
Thank you.
Your Honor, will she need fingerprinted?
She will be fingerprinted, so Mr. Cooper will bring you a form, you have to take it to the jail to get fingerprinted.
Was it just me, or was the printer unusually quiet for Dungeon Court? Usually that thing is constantly running and overtaking everything. I hope you all had fun today. I know I did. Thank you to all of you, not only for being here, obviously for being here, but for your chatting, your gifted memberships, your super chats. Lindsay, thank you for picking up something from the store. Just been a fun day. So much fun that we'll do it again on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier. If you are a channel member, I highly encourage you to become a channel member if you're not already. It's a whopping $2.99 a month, but it's totally worth it. Credence and Mikey from Credence and Mikey was in the chat here towards the end. Hi, Mikey. Do support their channel if you don't already. I'm sure most of you do, but if you don't, there is a link that Barbara dropped, so go pay them a visit as well. We'll have some more videos and stuff throughout the weekend, working on some things for the channel as well, and look forward to seeing you all Monday. But go have yourselves a good weekend. Be careful, have fun, all that kind of thing. Take care. God bless.